the council and for the bar council of Delhi. Audit from record filed last week. We are because I was yesterday observed that the investigation will not be yes, so my lords may give us just 15 minutes.
Whatever time is available, you request them. Yes. You are on which side? You adjust the time among them. If the time permits, because we will conclude it by tomorrow, 4 o'clock. Yes, Doctor.
My lords.
Your lordship has directed me to deposit some amount in your appeal order.
Mentioning it before court number 2 today.
Today.
The order is by your lordship's registry.
You can't mention it before CB. Have some maintain some decorum.
My lords, Article 233, 1 and 2.
Oh, Dr.
No, sir. And controversy arose with Satyanarayan Singh's judgment, my lords, where it said that there are two different streams of appointment, and they also found that my lords, it was an argument which was found acceptance that from
the notes given on the
judge.
You are appearing for whom?
I am appearing in 105.25. I am appearing for a person, my lords, a judicial officer.
Point?
At 501.25, Sudhanshu Upadhyay. My lords, he has completed 10 years, 8 years, 6 months before joining as a civil judge in 2015. And my lords, he appeared in 2018 in UP Higher Judicial Services, and his result is in sealed cover. Because he appeared in person to the orders. 501.25.
1.2.
yes.
He has completed more than 7 years. He has completed 8 years, 6 months as a lawyer before becoming a civil judge. He comes in that.
When did you become civil judge?
My lords?
When did you become civil judge?
My lord, 2015. 2015. And he took examination, my lords. He sat for examination on 2018, my lords. His results is still in sealed cover, is what I am instructions. In UP Higher Judicial Services. And he is serving in UP as a civil judge.
Now what, your senior division or same?
Senior division. My lords, the entire...
Individual matters will not be deciding. We will be deciding only the questions.
Yes, my lord, then matter will be left to the individual.
Matters will go back to the
respective courts, my lord, for this. My lords, the genesis of the problem arose, my lords, as I began, my lords, by stating that the locus of, my lords, a civil judge becoming a district judge would be under Article 233(1), and lawyer can become, my lords, advocate can become under 233(2). This separation is the basic fallacy, my lords.
That is done where is Satyanarayan?
Satyanarayan. It started with Satyanarayan, my lords, in specific terms, which is and my lords, Article 233 is, my lords, merely a declaration of appointment by the governor. My lords, Article 233(1) has a provisions, my lords may see, it is picked up from 1935 Act. My lords, just put it, my lords, how intelligently it has been, my lords, varied in our constitution, my lords. My lords may see article, my lord, this is, my lords, Government of India Act, which many people say is the, my lords, a basic of our constitution, but my lords, it has been tweaked very intelligently. That's all I want. My lord, can you run to section, my lords, the Article 254 or section 254 of the Government of India Act 1935. District judge, etc. My lord says it. Appointments of persons to be and the post.
It is already there in the comparison.
Volume 4, page 136.
Where is there?
Okay, volume 4.
Mr. Bhushan has already referred to it in his opening argument.
My lord, what he wanted to say was, my lords, yes, that exercising his individual judgment has been taken off. Now, my lords, this is only the governor who will be bound by the, my lords, the consultation with the High Court. So there is no, my lord, it is basically a freedom from any state interference. My lords, Article 233, my lords, only points out that there will be no interference by the state government or any other body. It is only the governor and the High Court to ensure independence of the judiciary. It is not the source of my lords appointment. Even Chandramohan says so. My lords, because there are many, my lords have already, my lords, held one constitution bench of powers of the governor. Here, my lord, the governor, my lords, is in consultation with the High Court. My lords, unlike my lords appointments in the higher judicial, my lords, in the constitutional court of
Exercising his individual judgment has been taken out.
taken off. And now,
Therefore, now, when if that is taken out,
my lords,
then he will have to act on the aid and advice of the.
Correct. my lord, meaning thereby, Article 233 is not a source of appointment. It merely ensures independence of the judiciary. That a judiciary is completely out of the control of the state government. My lords, kindly see, my lords, in the entire chapter of subordinate courts, there is no interference by the state in any manner. Unlike, my lords, appointments of the High Court and Supreme Court, where they stated in consultation with the state. Here, the state is, my lords, relegated to, my lords, it is akin to Article 192(2) of the Constitution, my lords, wherein the power of the governor is, if a person disqualified after elections, it is only the Election Commission. Here, only the High Court. So, my lords, 233(a)(1), the basic fallacy arose because 233(1) has been taken as a source of appointment for judicial officers. It is not a source of appointment. It is merely a declaration that yes, the appointment of district judge will be only at the exercise of jurisdiction by the High Court and nobody else. My lord, kindly see that the entire scheme is, my lords, as far as the, my lords, persons below district judge is concerned, Public Service Commission is involved. My lords, below district judge appointments, Public Service Commission. District judge, only High Court. Only High Court. High Court and, my lords, Honorable Supreme Court and Honorable High Court, my lords, even consultation with the state. Therefore, my lords, the entire purpose of 233(1) was not as a source of appointment for promotion of a district judge. It was appointment of a district judge deholds any interference by the state. And this is stated in Chandramohan's case also, my lords. 5 judges, my lords. They said that 233(1) is a declaratory in form. It was reiterated in 1969 3 SCC. Well, this position of law that 233(1) is mere declaration of, my lords, appointment of a judge. Even lawyer, my lords, advocate would be appointed at 233(1) only. So they are not separate streams of appointment. With this entire, yes, my lords. My lords, therefore, my lords, our submission is that 1969 3 SCC also. Same proposition that 233(1) is mere declaration of appointment.
Is that 1963? Which is that?
1969 3 SCC 505.
There is a citation.
State of Assam.
State of Assam versus Kumeshwar Saikia.
Volume 5, page 195.
Volume
5.1.
5.1,
Page 196.
page 195.
But it is mere declaration of?
Appointment. It is not a source of appointment.
Then what is the source of appointment of a district judge?
Source of appointment would be 233(2), both for judicial officers, or 235, my lords, for subordinate below district judge. And my lords, this argument was raised in even Dheeraj More's case.
What argument?
That, my lords, Article 233(1) includes appointment of both the members of the bar as well as judiciary.
Yeah,
Yes,
yes.
my lords, my lords, at page para 35 of Dheeraj More, it was raised. I'm sorry.
Stick to the old case first.
My lords, I'm sorry.
Don't switch over to Dheeraj more immediately.
Well,
It becomes
You
difficult.
said that this was taken out of.
690 SCC, my lords.
So what we are relying in 1969 3 SC for what purpose?
My lord, to state that appointment of, my lord, district judges under 233(1) is not a source of appointment. everybody who is appointed district judge, whether he is a lawyer or a judge.
So show us that.
Which paragraph?
Yes, my lords. My lords, may I read held that by reason of definition given in 236, the word judicial service would mean.
That is by the,
My lords, para 6. Para 6.
Para 6.
My lords. Para 6.
Just read para 3. So backward. If they understand.
Yes, my lords. Para 3 was, my lords, that he was appointed by the governor. They said that the High Court, it is not appointment by the governor, by the High Court under Article 235, and therefore this is a void appointment. So to that the answer is, my lords, at para 6, it means that the appointment as well as promotion of persons to be district judges is a matter of governor in consultation with the High Court, and the expression district judge includes an additional district judge and additional session judge. It must be remembered that district judge may be directly appointed or may be promoted from the subordinate ranks of the judiciary. The article is intended to take care of both. It concerns initial appointment and initial promotion of persons to either district judges or any of the categories included in it. Further, the promotion of district judge is a matter of control of the High Court. What is said of district judge really applies equally to additional district judge and additional session judge. Therefore, when the governor appointed Rajkova as an additional district judge, it could either be an appointment or a promotion in Article 223. If it was an appointment, it was a clearly matter under Article 233. If the
So it
notification,
doesn't distinguish between clause 1 or clause 2 of Article 233. It refers to the entire Article 233.
no, my lord, the argument,
Your contention that 233 1 is a declaration and 233 2 is a source.
correct.
But it does not take anywhere.
No, my lord.
Why, we don't know why are you arguing for that?
No, my lord, the argument was, this was argument also taken. The argument was that, my lords, that Article 233, my lords, appointment would embrace both advocates as well as the promotion. Article 210, yes,
We rephrase your argument. What you are saying is
my lords.
appointment and promotion come under Article 233(1),
My lord.
while Article 233(2) takes care of qualification only pertaining to the lawyer. We understand that, direction.
My
You
lord.
say appointment,
My lord.
which includes promotion, which gives the power to the governor in consultation with the High Court, come under 233, which means both categories, there is no classification there, both category will come under
Obliged.
this. And then so far as with respect to the qualification is concerned, it was made clear in subsection 2, we are not concerned with the one part, first part with this
My lords.
in-service candidates, and we are only taking into consideration of the law advocates and pleaders who want to have it over 7 years.
Correct, my lords. Our submission is, my lords, that kindly turn to Chandra Mohan.
Yes. Yes, from which page?
Chandra Mohan, my lords.
Yes. Yes,
My lord, SCR, internal page 89.
yes.
79 is what?
89.
179 of volume 1.
5.5. 1.1.
180.
Page 182.
Well, paragraph starting from,
My lords, so far there is no dispute. Internal page 89, my lords, of the SCR. SCR, my lords, have it, my lord.
89.
89.
Yes,
It says so in categorical terms.
yes, over there.
Page 192.
Yes,
So far there is no dispute. My lords, I'll just read.
We have read and reread it. How many times you want to read
No, my
it?
lords, all that-
There are 15 councils, should the 15
No,
councils read
my
it 15 times?
My lord, all that we are saying is, it says mere declaration. 233(1) is mere declaration, is what wanted to know. my lords.
come to the middle.
Doubtless, if Article 233 stood alone, it may be argued that the governor may appoint any district judge, whether legally if not, he belongs to any service under state. But Article 231 is nothing more than a declaration of the general power of the governor in the matter of appointment of district judges. This is what I want to say.
Correct.
That is already said.
Meaning that,
Yesterday, so many times
my lord,
that
85
insofar as
SCC,
persons from service are concerned, there is no qualification. Insofar as lawyers, there are two streams. One, in-service candidates in the service of the state or the union, and secondly, from the lawyer. Insofar as first category is concerned, there is no qualification. Second category, the qualification is minimum 7 years of practice.
My lord, my lord, how the difficulty arose because, my lords, in 1985, Satyanarayan said.
So you come to
Yes,
Satyanarayan then directly.
Yes, my lord. Kindly read.
Why do you want to go to the cases which have been read at least
Yes,
half a
my lord.
dozen times?
Satyanarayan, kindly see my Satyanarayan. My lords, kindly turn to para 2 of the Satyanarayan.
Where is Satyanarayan? Is page number?
Space 395.
394.
395, volume 5.1, my lords.
So दूसरा वाले में होगा.
Volume 5.1, judgments volume, page 395.
Same volume.
Yeah.
My lords, I will commend the arguments which were made 4 decades back. These are the real submissions, my lords. These are our submission, my lords. Para 2, which was rejected in this judgment. Para 2,
1 minute.
Yes.
Yes.
The submission of Sri Lada and Sinha and Kit was that there is no constitutional inhibition against members of any subordinate judicial seeking to be appointed as districts by direct recruitment, provided they had completed 7 practice at bar. The submission of learned counsel was that the members of the subordinate judiciary had put in 7 years of practice at the bar before joining the subordinate judicial service and who had gained experience as judicial officers by joining subordinate ought to be considered better fitted for appointment of district judges because of the additional experience gained by them rather than be penalized for that reason. The learned counsel submitted that the construction of Article 233 of the Constitution, which would render a member of subordinate judicial ineligible for appointment to the higher judicial because of the additional experience gained by him as a judicial, would be both unjust and paradoxical, unjust. It was also suggested that it would be extremely anomalous if a member of the Uttar Pradesh Judicial Services, who on the present construction of 230 is ineligible for appointment as a district judge by direct recruitment, is nevertheless eligible to be appointed as a judge of the Honorable High Court by reason of Article 2AA. Yesterday, my lords had pointed out this explanation. He would be eligible for becoming a High Court judge, but not for it, my lord, taking exams as district judge. On the other hand, my lord, this is how, my lord, the fallacy arose, my lord. Mr. Subramaniam, learned counsel respondent urged that there was a clear demarcation in the Constitution between two sources of recruitment, namely, those who were in service of the state or union to those who were not in such service. He contended the second clause of the Article 230 was attracted only to the second source. Now, this is, my lords, the problem begins. And in respect of candidates from that source, further qualification of 7 years as an advocate or pleader was made obligatory for eligibility. According to Mr. Subramaniam, a plain reading of both the clauses would show that while the second clause of Article 233 was applicable only to those who were already in service, the first clause was applicable to those already in service. He urged that any other constitution would lead to anomalous and absurd consequences. And such a member of
All the arguments not there.
Sir,
Hey, please.
you skip everything, come
Yes.
to Article 333
Yes.
as follows.
Yes.
Therefore, my lord,
These are all arguments.
my lord, I was pointing out both the argument. Now, my point is clear distinction, my lord. They put 229. My lord, the page, internal page, my lord. Now, this argument led to the, my lord, this bifurcation of 2 separate streams. And therefore, the entire problem arose. Therefore, I was reading both the submissions. In other words, as in the case of candidates, my lord, para 3, my lords, and the next page, 229. In other words, in case of candidates who are not members of a judicial, there must have been advocates or pleaders for not this, and they have to be recommended by the High Court before they become district judges. While in the case of candidates who are members of judicial service, the 7 rule has no application, but there has to be consultation with the High Court. A clear distinction is made between 2 sources of recruitment. Dichotomy is maintained. Now, my lords may turn to next page. Page 230.
Page?
230 of the same volume.
The road.
Internal page. Page 401. 401 page, my lords. Chief Justice Subbarao then proceeded to consider whether the government could appoint a district judge's person from services other than the judicial service. After pointing out that 233(1) was a declaration of general power of the governor in the matter of appointment decision, he did not lay down qualification of candidate to be appointed or denoted source from which the recruitment had to be made. He proceeded to state, but the source of recruitment is indicated in clause 2 of thereof. Under clause 2, sources are given, namely this and this. The source is 233(2), but my lords, kindly see reasoning which is at para 5. This created the entire problem.
That's because the council argued that this case, the case of the in-service candidate also should be brought under the 233(2). That was a problem.
Yes,
The council also did not understand. Unlike what all of you are arguing, now your argument is totally different here.
Yes.
Your argument is, 233(1) is a comprehensive provision. It takes care of everything.
Yes, my lord.
233(2) operates on a separate field with restriction only to that.
Obvious.
Therefore, there is no question of fitting in a judge who's already serving into 233(2).
Correct.
That's all we say. That the argument is different. Therefore,
Para 5, my lord, makes
considering it wrongly.
para 5 made all the difference, my lord.
It's all right.
And this was reiterated in Dheeraj Moore's case.
Yes, all right.
Dheeraj Moore's case. This
The main reasoning seems to be at 401, that otherwise they will steal a march over people.
Or the others who are all senior to them.
but here it's open
That
competitive.
doesn't matter because
Doesn't
There
matter.
was question of 7 years,
Service.
question of recommendation High Court, all those things will not come. It's correct only. In a way, that's correct, because now, whatever you say, that's irrelevant, because the argument of your colleagues is only this. You just 233(1) does not exclude to mean there's a separate channel, and for direct recruitment, it doesn't apply. It merely says about the qualification. For that, they make it very clear. That's why they say you can't leave certain portion of the article, and you have to read it in entirety. Every word has got a meaning. So you have to read it, and then it's only speaks about if you're a lawyer, advocate, or pleader, you require 7 years. That is not mentioned for the others. Yes.
And the point we want, it is not stealing marks. It is an open
yes.
open competitive exams. And my lords, Article 14
yes,
and
now,
my lords, I'll just last. My lords, the point we want to make is, my lords, that as far as my lords, this district judge examinations are concerned, they will come within the ambit of public employment. My lords, maybe the constitutional functionaries of High Court and Supreme Court may not be termed as public employment so far, my lords. But examinations till the district judge are part of the public employment as enshrined under Article 14 and 16 of the Constitution. Therefore, my lords, whenever you have a competitive exams, the law is that you should have the widest possible net so that you can talent the best possible talent available. So to exclude, my lord, that was the argument of Lal Sinhaji and Vinu Misra.
yes,
Problem is you are trying to repress it.
you are already,
See,
what step you are trying to
simply put, what they are saying is there is no reservation.
Very well.
For the advocate, we'll put it that way.
That's all.
Yes, all thank you.
I'm sorry, my lord.
No, it's all right.
Oblige.
May it please, Millets. I appear in 501, the lead matter, and also 501.20 Millets, two judicial officers from two different states. Millets, one remarkable thing is that Millets, my lord's adherence to the timeline. I am grateful, and I will not exceed my time.
Yes.
Millets,
10 more minutes of mine.
Millets, though it's been argued extensively on the questions of law
Sorry,
and the
the
presidential.
which matter and which matter?
Millets, 501 minutes. I appear. And 501.20. Yes, I believe. Yes, Millets, 20.
Yes.
Millets, it's been extensively argued on all counts. My turn, it seems, is that, Millets. The facts have not been put in perspective in the lead case. It's a peculiar case.
So we are not going into the facts of the case.
So be it.
We have made it clear that we will be answering only the questions that are referred to us.
Right. Then, Millets, this case stands squarely covered by a judgment rendered by your lordships, the Honorable the Chief Justice of India, as his lordship then was, in Sunil Kumar Verma's case. Identical facts, but for one distinction. In that case, Millets, an officer It's been there in the compilation. An advocate applies for the post. While the recruitment was on, he gets the post of Civil Judge Junior Division. Thereafterwards, Millets, he seeks the permission of the High Court and then appears for the district judge exam, both prelim and main. Eventually, when he's been selected, he sought the permission of the Honorable High Court to resign. And he resigned. Thereafterwards, he joined. Then, Millets, in course of time, Dheeraj More was decided. The Honorable High Court on its own issued a show cause notice and said that now Dheeraj More says that you could not be because you were in service then. Thereafterwards, he was removed. Then that's reached your lordships. Your lordships have held that at the time when he applied, he was not in service. Pending that one, he came into service. But by the time he joined the next post, that's district judge, additional district judge post, he resigned. All under the supervision of the High Court. Hence, it cannot be found fault with. My lords have had, Dheeraj More has no application to this one. In my case, Millets, only that distinction my lords could see. When I applied, I was a lawyer, not in the judicial post. Waiting for my turn to be selected, I got the post as a Civil Judge Junior.
You are protected, I think. You are protected by the...
I've still been in service, Millets.
Your facts are already told to us by Mr. Gupta yesterday.
Maybe, Millets.
You're continuing as a district judge now.
I'm still continuing, Millets, but it's been hanging. Certificate was issued in this case, Millets.
You are
Kerala.
Indeed,
You are adequately safe. So, okay.
Yes, Millets. That's the only endeavor, Millets. The distinction here is that, Millets, when I was the junior civil judge, I was discharged from service instead of resignation.
Argue only on the question.
Millets. Sunil Kumar Verma may take your lordships to that one, or else, Millets, it's been fresh in your lordship's memory, it may not be required.
Sunil Kumar Verma, you are not gone through.
So be it, Millets. Kindly come to Sunil Kumar Verma, Millets. Millets, in the compilation of their judgments, my lords could see 1075, volume 3. Sorry? 5.3 minutes.
How many compilations of judgments are there?
There is 7 compilations.
Judgments?
I was told, Millets.
This will be PDF 299, 5.3.
The running number is 1077, where my lords have set out the facts and then rendered the judgment. This is said to be 5.3.
What is the citation, please?
Millets, citation. This is 2022 9 SEC 686. 86. Para 2 sets out the fact, Millets. At page 1077. Para 2 Millets.
Yes.
Last 3 lines. Calling upon the appellant to show cause the High Court of Judicature at Patna, thereby calling upon.
Read from the first line.
Beg your lordship's pardon?
Read from the first line of the paragraph.
By the said writ
Now you
petition.
also adopted yourself to the Supreme Court practice
Yes, Millets.
of selective reading.
I will read, Millets. By the said writ petition, the appellant had challenged letter number so-and-so, dated 18/5/2020, and letter number so-and-so, dated so-and-so, issued by the High Court of Judicature at Patna, thereby calling upon the appellant to show cause as to why his services from the post of additional district and session judge should not be terminated in view of the judgment of this court in Dheeraj More versus High Court of Delhi. By way of an amendment to the petition, the appellant has also challenged letter number so-and-so, by which his services in effect were terminated. Then para 4 minutes, the facts and brief leading to the present appeal or agenda. The High Court of Judicature at Patna had invited applications for recruitment to the post of additional district and session judge. The appellant at the relevant point of time was an advocate having completed practice of more than 7 years. As such, he was eligible to apply for the said post. Accordingly, he had applied prior to 16/9/2016, which was the last date for submitting the application. Para 6, my lords, may kindly see. In the meantime, the state of Uttar Pradesh had invited applications for the post of civil judge junior division. The appellant has also applied for the said post. After being successful in the selection process, he was appointed on 16/1/2017 as a civil judge junior division. Para 7 minutes. After the appellant's appointment in the subordinate judicial service in the state of Uttar Pradesh, the selection process for recruitment in the Bihar Superior Judicial Services proceeded further. After obtaining the requisite permission from the High Court of Judicature at Allahabad, the appellant participated in the selection process conducted by the High Court of Judicature at Patna for the post of additional district and session judge. The said selection process consisted of etc. Per 8 minutes. With a notification dated 7/8/2018, the appellant was offered appointment. The appellant therefore obtained permission from the High Court of Judicature at Allahabad for resigning from the Uttar Pradesh Judicial Service so as to join his service as additional district judge in the state of Bihar. 9 minutes. Consequently, the appellant joined the Bihar Superior Judicial Service with effect from 21/8/2018. In the meantime, the judgment of this court in Dirajmore was delivered on 19/2/2020. Kindly come to parent 10 minutes. On the basis of the said judgment, the High Court of Judicature of Patna issued a show cause notice as referred to here and above. After considering the reply, the High Court of Patna recommended the cancellation of the appellant's candidature. Para 12 minutes, that's the argument. I need not trouble your lordships. Then kindly come to para 15. The present appeal arises out of peculiar facts and circumstances. Then my lords have said, undisputedly, the appellant had applied in response to the advertisement issued by the High Court of Judicature at Patna. As on the date of his application, he was a lawyer, having practiced for more than 7 years, and was therefore very much eligible to apply for the direct recruitment category. Kindly come to page para 18 minutes. 17 should I have minutes. Para 17. In the meantime, the selection process conducted by the High Court of Judicature at Patna, which had come to a standstill, proceeded further in the year 2018. The appellant, therefore, after obtaining the requisite permission from the High Court of Judicature at Allahabad, participated in this selection process, in which he was found to be meritorious. After being selected, he applied to the High Court of Judicature at Allahabad for grant of permission to resign so as to join the state of Bihar as an additional district and session judge. It could thus be seen that, firstly, the appellant was neither in service of the Bihar subordinate judicial service on the date on which he applied, and secondly, nor was he in the service of the Bihar subordinate judicial officer's cadre on the date on which he was selected. My lords may kindly come to minutes para 20. That's the crux of it. It is further to be noted that the appellant was vigilant enough to seek permission of the High Court of Judicature at Allahabad before participating in the selection process. Not only that, after he was found meritorious, he again sought permission of the High Court of Judicature at Allahabad to resign from the said services so as to join the Bihar Superior Judicial Services. My humble submission, the only distinction is Millets.
Not correctly decided.
Beg your lordship.
This is not correctly decided. This is a judgment by 2 judges.
Millets.
It was bound by Dheeraj More. Dheeraj More is of 3 judges.
Millets.
Either Dheeraj More was not.
My learned friends have argued extensively. If I am allowed, I'll argue on Dheeraj More's soundness.
But Dheeraj More clearly says that he has to remain an advocate till the time he is appointed.
Millets, that's not to be found anywhere in the Constitution. Article
That is what
233.
Dheeraj More says.
And my lords could not read a sentence.
Two judges were bound by Dheeraj More.
Millets, in that view of the matter, we find that the law laid down in Dheeraj More is not applicable in the peculiar facts and circumstances of the present case. So that's how my lords are distinguished. Millets, there are many devices to say and not to say on the face of it that it could not be the correct law.
Who knows better than you?
Millets, since my lords have said Millets, I have got time, a couple of minutes, Millets, because
It can't be said to be Parimgire because Dheeraj More has been referred to. But Dheeraj More has not been corrected.
it's been referred to Millets. And my lords have held that on factual aspect, it's completely different. So that's why, Millets, even strength of higher cadre, rather judgment, Millets, would not dilute once it's been referred to. Millets, here, the only distinction my lordship may appreciate. He was in one state as an
We are not
officer.
going down the facts of it. We are only deciding the questions of.
So wait, Millets. Millets, now Millets, my lordship may kindly appreciate.
Saying from yesterday that if we decide question number 4 in the affirmative,
Yes, Millets.
everything would stand over.
Millets. This case apart, Millets, I may plead on behalf of thousands of young, brilliant
Don't give
lawyers.
Don't give a speech here.
No, Millets, I'm not giving. I'm only submitting the fact. My lords may kindly appreciate the profile has changed.
From the Bar Council of the
Millets, the interpretation, my humble submission is, must be purposive. My lords may kindly appreciate, for whatever reason, maybe financial compulsion or love of profession, being a judge, my lords have seen somebody could make tons of money as an advocate. Still, they volunteer to be judges, be it of whatever grade, even High Court and this Honorable Supreme Court. Still,
and some of them resign from the services.
To make money.
And then make tons of money.
Millets, that shows that just because somebody has been in service cannot be a discounting factor for him to be selected at the higher level. His services are needed. My lords could see gold medalists, Ivy League graduates and postgraduates. They've joined as junior civil judges. And they cannot be Millets. And one more submission, Millets, that I gathered that it should have been 7 years continuous service. Millets, with great respect, the interpretation when it comes to 233(2) Millets, it doesn't speak of continuity. I may just give one example to that effect, Millets. Somebody may practice as a lawyer in a high court for 5 years. Then he gets a job in a bank and he leaves. 5 years, 6 years, he works in there. And he comes back. Then again, he works for 9 years, rather practices 9 years as a lawyer in a high court. Then put together, he has completed 10 years as was required, 217. Then, Millets, in that context, can we say that he's not qualified to be a judge? And perhaps they prove to be one of the best judges? And continuity, Millets, may not be read into because it becomes quite narrow.
Disconnect to the profession, sir.
Millets, disconnect to the profession.
By an individual.
Millets, may I submit, Millets?
So Naidu,
Yes, Millets.
by an individual example,
Yes, Millets.
you cannot lay down the general principles.
There are others also, Millets, with the same example. Millets, disconnect. My friend pointed out, Millets, Krishna Iyer was a minister. And Millets, Chief Justice John Marshall, the greatest Chief Justice, did not complete his law. And American Constitution has never provided for qualification as law degree is not a qualification there. A doctor has become a judge, Supreme Court judge.
Cannot be taken into consideration.
I'm saying, Millets, continuity may not be. It's only the passion. And at the end, the qualification. Because for various circumstances, they may be compelled to have different options. Once they come back and they continue, this restriction, Millets, given our economic conditions.
Wait for 7 years.
That's all, Millets, my submission. If it were to be a speech. Millets, I appear in 501.20 also, Millets.
Very well, not.
Since my lords are not inclined to have the facts, Millets,
After we decide the question, the matters will go back to the.
so be it. I'm grateful for the opportunity, Millets. Great.
Whatever, if the review is allowed,
No, 501 is substantial. It's an appeal.
we are answering the question. Once the questions are answered, then the review petitions will go back to the benches and they will be decided in accordance with
So be it, Millets. Grateful.
whatever has been held by, whatever
Great.
will be held by the.
Grateful for the opportunity, Millets.
Like the reviews can be allowed, because once your lordship comes to the conclusion that Dheeraj Moore was wrong, then the reviews will be allowed. In fact, your lordship had already came to the conclusion that it was already referred to a constitution bench, wrongly heard by 3.
Yeah, after answering the question, pose the individual matters.
One of the questions which
They would hardly take half a day sitting all those 20, 30 matters.
just Lord, that rule would also have to be quashed, which Lord does not permit civil judges to be there. Don't leave that for the regular bench. That must be decided by the Constitution.
Millets, in the cases I appear, all 3 judicial officers are still continuing.
All 3 of them, you are lucky.
Great.
In Girajmore also continue.
He doesn't continue. Continue.
Rajneesh can.
Not as a, not as a district. Selection was kept in a green.
Rajneesh is continuing, the Vaisara one, he is continuing.
They will bring consideration.
Village was not allowed to participate.
Not allowed to.
The inter,
Yes.
Your lordship may recollect, he was appearing in court. He was before your lordship every day. Till your lordship said that. No. It's not proper for you to.
he was not first. He was not.
No, that was somebody from the Delhi district. Judiciary. When I was sitting with Justice Nageshwar Rao.
Those were two brothers who used to come from Delhi.
From Delhi.
Yes,
Justice-
I was appearing for them. When your lordship said, you should go to court, what are you doing standing there?
Court 5.
Court five. I was appearing. Yes.
Yes, Mr. Punat, you are appearing for whom?
I'm appearing Vaisara one for them. Since I do has covered the point, I have, because I have nothing more. Your lordship said, it is being said to the
No, you are appearing for?
Vaisara one, because.
Same. Girajmore.
Same. So that there is nothing more to argue in this matter. Rajneesh. Yeah. We were arguing, we are appearing together in the matter.
Okay. Thank you. We are recorded your.
May it please, Manoj?
Yes, Mr. Punat.
Manoj, I appear in 50.1.11, possibly one of the most unfortunate cases. I practiced for more than 11 years. I topped the civil judge's exam, appointed as a civil judge, practiced as a civil judge.
You are in?
501.11, yeah. Give copies. Give copy other side of. Just one page. Manoj, just-
For a change, you are not
my
for
proper-
intervener.
No, not the interview, for a change, yes. Yeah, I just give it to him also. I've just put my relevant facts. I'm not going into the facts. I'm just saying what happened. So after topping it, he participated in the district judge's exam after in his 32 petition, your lordships permitted him to participate. And he topped that as well, the exam. He's appointed as a district judge in 2018. After in 2010, he had participated, he had topped the exam cancelled. 2018 participates, tops, he's a district judge. Then the matter is here. While he's a district judge, the Dirajmore judgment comes. Next day, they repatriate him. Next day, 19th, Dirajmore, 20th, repatriated. So as of now, he has been repatriated. It's a moment of great anguish. He's had a heart attack, 3 stents, etc. It's a shocking thing for to happen to a person. But anyway, now on the law, my lords. Your lordship have gone through judgments. 2 things I want to say on judgments your lordships have already seen. On Rameshwar Dayal, specific question number 2 framed with reference to has been, that is specifically answered. Facts are relevant, but your lordships have gone through it. Just look at those 2 respondents again. Interesting, actually, a large part of this judgment deals with the 2 portraits which are in our neighboring courtroom. Justice H.R. Khanna is one of the 5 people mentioned in Rameshwar Dayal.
He was not from the services.
I'm sorry, Manoj?
The question with
He was
whether
he was not. He was the other 3.
His practice at Lahore could be taken into consideration.
To be taken. I agree. So he was not, he's on the other 3. We are only considering those 2 for the purposes of our facts.
Swani and.
Correct. The other one is even more interesting. Justice Iyer's portrait, which has gone for refurbishing. Justice Iyer was a judge of the Madras High Court. In those days, retirement was 60. So he passed 60, he had retired. It was after he was retired that he was brought to the Supreme Court as a judge. That's actually happened many times after that, including Justice Fatima Bibi, many others, Justice Baharul Islam, the other Justice Iyer, all of them. In fact, the other Justice Iyer stayed on till the age, he must have been the longest serving in this court, age of 68. He was as an ad hoc judge twice appointed thereafter, after being a judge. So the fact that you have an interval where you don't continue being a judge, but you're reckoned and appointed, it's happened here. 5 times it's happened in the Supreme Court itself. Now, just coming back. So Rameshwar Dayal, that. Second, on what the other Dr. Singhvi showed your lordships this morning, with reference to the state of Assam case, that one sentence in the middle is very, very important. In the middle of para 6, they were talking about the individual concern. The individual concerned in that case, specifically, open that para 6 and show. the individual in that case specifically, that's the state of Assam case.
Chandramohan.
Yes, if I can, Raj Kova is his name. He was the district registrar. That's a constitution bench.
You are Satyanarayan.
No, this is state of Assam versus Kusheshwar Saikia. This morning, Mr. Singhvi, Manish Singhvi showed your lordships. One judgment, 7 paragraphs long.
1969.
That's the one. That's the one. In that, that was a person who was a Munsif, Malod, who was acting as a registrar in the Assam in Guwahati High Court. So that gentleman, as far as he was concerned, it was a question which arose regarding his promotion. But if you see the middle of page 200, para 6, it's in volume 5.1, para 6. I want you to just see the middle.
Yes.
And it's important because this paragraph, the first 7 lines are extracted in Dheeraj More. And then it suddenly amputates itself and stops and doesn't go on to the next 2 sentences, which would have made a huge difference. The middle of the paragraph, can I read? Therefore, when the governor,
Yes.
about 5 lines down.
Appointed Raj Kova.
Yes, when the governor appointed Raj Kova, an additional district judge, it could either be an appointment or a promotion under Article 233. This is important because Raj Kova was actually a judge. He was a civil judge, a munsif who was acting as the registrar. On the facts, the Constitution bench notes that Raj Kova is eligible both streams. This is why this sentence is important, because the Constitution bench is grimly aware even then that you can come in even if you are a judge. You can come in as an advocate. This sentence is important for that purpose. So I'm just redrawing as far as the facts are concerned that the court is aware that Raj Kova, being a judge, could have come in as an advocate. Therefore, it goes to 233(2). I will, don't worry, I will. If it was an appointment, it was clearly a matter under 233. If the notification be treated as promotion of Raj Kova from the junior service to the senior service, it was a promotion of a person to be a district judge, which expression as shown above includes an additional district judge. In our opinion, it was the latter. Thus, there is no doubt that the appointment of Raj Kova as additional district judge by the governor was a promotion and was made under Article 233. It could not be made under 235, etc. Unless Mr. Singh wants me to read something else which he feels frighteningly relevant here. Was it error?
There the High Court found that
Correct.
he could be promoted only under 235
Correct.
and not under 233.
Correct.
And
Correct.
The Supreme Court reversed that,
Yes.
holding that the power to appoint and promote
Both fall
also
under 233.
flow in 233.
I'm grateful. I'm grateful. But while saying so, shorn of the irrelevant sentences my friend wants me to read, the relevant sentence in my view is the middle one. Now, if you, lordships, just note.
Which have been amputed according to you in the Dheeraj More?
In Dheeraj More, para 35 extracts, and if you keep these side by side, this is at page 138, right? That's the other one, SCC volume, no? Mr. Patwalia.
That is a Patwalia's
Mr. Patwalia's volume, page 138. So all 3 constitution benches which have some bearing on this, all 3 are ad idem in our favor.
Patwali ka compilation. SCC one. Right. Para 45.
35 at page 138 of this. 138. The truly well-prepared court masters have all the post-its kept on the side of their stool so they can flag it immediately. If I can just read that, para 35, it was submitted that ultimately the appointment of the bar member is also made under 233(1). In state of Assam versus Kusheshwar Saikia, this court observed, and it extracts para 5, para 6, and then it suddenly stops where it concerns initial appointment and initial promotion of persons to be either district judges or any of the categories included in it. And then says the decision is of no avail, as the question in the present case is different. Though the appointment is made under 233(1), but the source and the channel for judicial officers of the promotion and for the members of the bar is by direct recruitment.
This is contrary to what,
Exactly.
because
If
research holds that sources are common
Common,
for both
exactly.
promotion as well as.
Exactly. So if they had, and this is why facts sometimes bear relevance when you're going through judgments, especially for a constitution bench. Your lordships are laying this down, it will be cited forever. It's necessary for us seeing the background in which each of.
It is overruled by 7.
No, I'm hoping that won't happen, Malats, because again, everybody involved will be imperiled once again. So now I'm done with that.
The one thing is, there are 6, would have been a little bit more clearer.
It could have been, but I don't think they, yes.
233 only deals with appointment.
Correct.
Is whether you promotion or a direct appointment, it's a modes of appointment.
Yes, it is.
Both are dealing with appointment. That's what they actually meant.
Correct. That's what they meant.
You can call a promotion, in which case lawyers will, advocates will not have a role.
Correct.
The other is they direct appointment. But no, by way of promotion, you will be appointed.
That's
because it is his service itself. No, that's why the difference between you see 233 and 234.
Correct.
234 speaks about recruitment.
Yes.
233 speaks about appointment.
Appointment. That's true. That's
true.
No, that
The argument of the state,
yes,
as well as the respondent, was that it was a promotion under 235.
Yes.
That has been rejected by the constitution.
Squarely saying that it comes under 233. So that answers the question. Now, because your lordship are going on strict timelines without rejoinders, I want to raise what I think are 2 arguments which they have made in their written submissions and how we would meet them. So if your lordship will just bear with me for a minute on that. These are their arguments. First is dealing with the other 2 provisions dealing with Supreme Court appointments and High Court appointments, 124 and 217. If your lordship will just take the Constitution with me for a minute. Article 124, Manoj.
Those volumes.
The Constitution.
Shankar edition. Yes.
Article 124.
124.
There are explanations which have been inserted in both 124 from the inception and Article 217. Now, their argument in a nutshell is that, look, there is no such explanation in 233. Therefore, as when you reckon the period, you can't reckon the period that they were advocates. So please just see 124 first. 124, explanation 2. 124, as your lordships are familiar with, the candidate must have been 5 years a judge of a high court or of 2 or more courts in succession, has been 10 years an advocate, and of a high court or of 2 or more such courts in succession, or C, is in the opinion of the president a distinguished jurist. Unfortunately, us poor advocates of the Supreme Court are not included in this because we have to be advocates of a high court or 2 or more high courts. But anyway, explanation 2, my lords. In computing for the purpose of this clause, the period during which a person has been an advocate, any period during which a person has held judicial office not inferior to that of a district judge after he became an advocate shall be included. So this has a specific inclusion with reference to the period that will be reckoned. Now, this is dealing with where you are an advocate, your period as a judicial officer will be considered, not the other way around. We are arguing the other way around, that I'm a judicial officer, please reckon my period as an advocate. This is not an explanation that deals with that. This is an explanation that deals with the opposite. Now please come to Article 217. In 217, Clause 2, again, 10 years held judicial office or 10 years advocate. The explanations, there are 2 explanations relevant to us. First is A, this is under 217(2)A.
Explanation?
Explanation A and AA. A and double A. Double A was inserted, my lords, after the tribunal's provisions came into the Constitution, 44th Amendment, for the purpose of ensuring, including the service in the tribunal. AA came to be inserted. A was there from the outset. So if I can just show A and AA. In computing the period during which a person has held judicial office in the territory of India, there shall be included any period. Please note the words after, because that's fallen for interpretation by a 3-judge bench here. After and he has held. After and has held have both fallen for interpretation. Any judicial office during which the person has been an advocate of a high court or has held the office of a member of a tribunal or any post under the union or state requiring special knowledge of law. Now this is A. B. AA. In computing the period during which a person has been an advocate of a high court, there shall be included any period during which the person has held judicial office or the office of member of a tribunal or post under the union or state requiring special knowledge of law. Now this AA is similar to the explanation under 124. If you want to calculate the period when he has been an advocate, you will include the period as a judge. As I said, ours is dealing with the converse case. Now that converse case may have been in some way covered by A, because A says, in computing the period during which a person has held judicial office, there shall be included any period after he has held judicial office during which the person has been an advocate of a high court. The reason this provision fell for interpretation is that it came up in the case of Purnima, my lords, which your lordships will find. I'm just giving you the citation is 2023 12 SEC 519. It is at page 1080. I'm not reading the judgment at all of volume 5.3. 1080 of 5.3. It's a 3-judge decision.
Page number
1080, authored by Chief Justice Bobde. Now, that judgment is dealing with a situation where it's not after, but it's before. So, this explanation says that for computing the period the person has held judicial office, they include any period after judicial office during which the period has been an advocate of a high court. This provision was interpreted because people who had been advocates prior to them being judge of any sort said that, look, that period should be included in reckoning. The court said, you want us to read after as before. Constitution doesn't permit it on a plain reading because an explanation exists. That explanation came in expressly to exclude the prior period. That you can't, when reckoning judicial office for the purposes of 217, include within that a period when you were an advocate prior. I hope I'm making myself clear. It's only that after a judge you have been an advocate, you can calculate that. The absence of such an explanation in 233 endures in our favor, not in their favor, because there's no before after now, which controls 233. So the period when we were an advocate obviously must be added to the period that I was a judge. In my particular specific case, it doesn't matter because I have 7+ in both situations. But I'm saying generally on the proposition of law, that earlier period has to be added to the judicial period because the explanation is absent. And the other two explanations in 124 and in AA of 217 have no bearing because it's calculating for the purpose. I'm sorry.
Explanations are absent. Where is a question of now 233(2) specifically refers about the qualification.
Correct.
Which is required for
which is
if it is absent, where is the question of inferring something?
Exactly.
And then
I'm grateful. I'm just saying this is because this is an argument they've taken. The second argument which I could perceive is this. Rule 14.
Talking about eligibility, we can't just in the absence of anything.
Absolutely.
You can say
yes.
There have been judicial officers. Now 233(2) says with the recommendation of the High Court so far lawyer is concerned.
Yes.
They are already under the control of the High Court there.
Yes.
235 is there and other provisions are there. Therefore, it is presumed that the High Court has got ample jurisdiction consulted with frame the rules or regulation with respect to the their eligibility.
I'm grateful.
To that extent, we can appreciate it.
I'm grateful.
Yes.
The second, if you just pick up my note,
Yes.
the other argument, I'm sorry, I'll just wrap this up in 2 minutes. The other argument is that there is a rule 14.
Yes.
I am anticipating that they will argue this. It's not expressly there in their written submissions, but it should be because it goes to the facts of the case. In Chandra Mohan Malad, there were a bunch of rules that were challenged in the Chandra Mohan Constitution bench. Those rules were not expressly struck down, but they were read down. If they were to make the argument that Rule 14...
On the rule which permitted an executive magistrate.
Correct.
Was struck down.
Yes.
It was held to be quality of the doctrine of separation of powers.
Correct. One of the arguments they could take, I don't want to be supplying it, but because we won't have a rejoinder, I want to just say...
We know what you are saying. Yes.
Yes.
Only they raise it.
Yes. So that Rule 14, which is extracted in Chandra Mohan, if the striking down of that rule has the consequence of shutting the door on us, I don't believe it does, but it's possible that they will take that argument after reading the rule and trying to read it in a way that it will shut the door to us. I want to say that that will have absolutely no bearing in view of the subsequent clarifications that have come in judgments. Chandra Mohan 2 also exists, but it's not germane for the purpose of this, just for understanding Chandra Mohan 2. If you see this note now, Roman 2 in my note is again on the held and has been point that it has been construed by 2 judgments in the context of 217. I've given the page number at, give me the page numbers of, where's that? Updated, why you give me an old note?
929.
Yes.
At 946.
Correct.
947.
Correct. So please just see that. The at pages at 9, where is, do you have? 946, whatever the printout says. 946, 947, and at page 635, these 2 deal with it. I've given the 6, I think, very serious errors which are there in Dheeraj More.
Yes.
And in any event, in my view, Malaj, in public interest, when you're looking at it, it has to be a larger pool of judges. We have the statistics as far as this particular state, which is Telangana, is concerned, where the numbers show us that after Dheeraj More, we have vacancies, we don't have people to fill them.
No, yesterday also we said that we will not go to that.
I'm grateful. I'm grateful for a patient here.
Before my learned friend starts, there's an interesting story regarding Rajkua, who was appointment, my lord. Upendran Rajkua, he was a district judge. He was convicted for murdering his wife and 3 daughters and sentenced, my lord.
Sentenced to, but then that was set aside.
And sentenced to death, my lord. And he was,
Yeah, but then that was set aside by the High Court.
no, that was upheld by your lordship. He was executed by this court. He was sentenced to death by the district judge, affirmed by the High Court and this court. Finally, he was executed for murdering his wife and 3 daughters. And buried in the official residence of the district judge, Dhubri.
May I be excused?
Yes. Yes.
Well, I'm appearing in the very matter in which my learned friend, a few minutes, my lord, that I will not repeat what.
Don't permit 2 lawyers for one matter. That's a.
Please go into the fact. Don't go to the facts. They already said.
No, I am not going into facts. Only one sentence in the Chandra Mohan's case, I will draw your lordship's attention to that, my lord. That is at page 192 in para 16. Their lordships are categorically held that for 233-2 appointment, 2 sources are there. One is from service and the other is for advocate. That was not disturbed at any point of time. Categorically held, my lord. So once these in-service candidates are held eligible to be considered for 233-2, there is no question of excluding judicial office. Now, my lord, wherever the Constitution wanted to either disqualify or exclude any particular category, it was very specific, my lord. I will only draw your lordship's attention to few articles. For example, Article 58, the deal 58. Well, very quickly, my lord, I'll refer to the articles and I will not take much of your lordship. Only by way of illustration. Dealing with the President of India, my lord. No person shall be eligible for election to the president as he is unless he is a citizen of India, has completed the age of. So many things are there. So the provision was very clear in clear terms that exclusion. wherever the exclusion, the parliament or the constitution wanted to exclude a particular category, the provision was very specific in negative terms.
Here there is
Similarly,
no
for,
exclusion. On the contrary, this provides for qualification as to
no, I'm only trying to,
qualification.
Referring to 58.
58.2
No percent, no percent. Very good.
shall not be,
Said no percent.
both, in both ways, my lord. The in both ways, 58.1 as well as 2, they are couched in negative terms. Similarly, 157 for governor, 63, I am only referring to save your lordship time. Article 66.3 for the vice president. Article 84, my lord, for members of parliament. That is still categorical, and Article 84.
Article
84, my lord.
84 is for member of parliament.
Member of parliament. 84. A person shall not be qualified to be chosen to fill the seat of parliament unless he is a citizen of India, so on and so forth. In addition to that, my lord, 102, Article 102, how they process disqualification. If a group of persons are there, and if a particular group is to be disqualified, there also the constitution is very specific. The persons may appear to be falling in the same group, but if a particular group is to be disqualified, the provision was very clear. 102, my lord. Similarly, in the case of course, 217 and 124, your lordships are aware, the appointment of judges, it is couched in negative terms, sir.
Please appreciate there's a difference between qualification and eligibility.
Yes, madam.
There is indeed a difference. There are subtle differences.
Now, I am only coming to this
About
233.
qualification. We are not talking about qualification.
No, now coming to 233, it does not say that a particular category.
I appreciate that, but what we are trying to tell you is that speaking about qualification is about eligibility.
Yes, ma'am. It does not disqualify any. Whole difficulty is, if that word only is shifted to displace that after if the whole controversy will stand. That was done in the case of, by translation. And translation by the provisions of Constitution itself, my lord, Article 394 makes it clear that the Hindi translation will be authentic even in the event of there being any doubt or clarity. Here, the Hindi translation category is only such person, if he is not in state or central service or judicial service, he shall be eligible if only he has got 7 years of standing at bar. That doesn't mean that the person in the service is disqualified. Had that been the intention, the words would have been very clear that these persons will not be eligible to be qualified. And it is not uncommon, my lord, UPSC, if a person is already in IPS, he can compete for IAS, examination is same, and wherever they want. For example, in LIC, my lord, if they want to appoint the post of, fill the post of attender, they will exclude the persons who have studied over and above metric. So the appointing authority or the constitution or rule making authority will be clear wherever they want to exclude or disqualify. Both the things, either exclusion or disqualification. None of them is present in Article 233.
Your argument should be, it speaks about eligibility.
Yes, madam.
Qualification is different.
Yes, madam.
For example,
Yes.
somebody is of
Yes.
insane mind.
Yes.
Somebody
No.
is
Yes.
solvent. Will be disqualified.
Yes, madam.
Eligibility means.
Yeah, eligibility.
Listen.
Yes, eligibility, madam.
Why don't you allow us to say? You are otherwise qualified. We are only trying to tell you in your favor only.
Yes, madam.
You read subsection 2.
Yes, madam.
It does not disqualify
Yes.
the service candidate.
In service.
But it gives an eligibility to the lawyer, which means lawyers themselves is not disqualified.
Yes.
But whoever will be eligible within that group.
Yes.
Therefore, what you have to say, disqualification is not there.
Yes, sir.
It speaks about only eligibility.
Eligibility.
That is the reason why
Yes,
it does not deal with the other thing, and then it clarifies that eligibility is only required for only B category of persons, not A.
Yes.
To that extent, we agree with you.
Yes. And that part of it was very clearly mentioned in Chandra Kumar's constitutional bench of the Honorable Court in para 16 category. I am much obliged to your lordship for providing this. 7 years. Yeah. 7 years. 7 years. It can be in terms of the service or the. My lieutenant has just. They are virtually interchangeable in the sense slight change as to the timing, the practice at the bar as well as service in judiciary. Ultimately, the aim is to ensure the best qualified candidates are there selected for this purpose. And
That is already done.
yes,
Thank you.
much obliged. Much obliged.
Yes.
May it please, my lords. My lords, my submissions are filed in volume 1, written submissions for the petitioners. I've just prepared a very brief 2-pager also. I'll hand that over, just that summarize these submissions. They're not very long. They're about 12 pages. But I'll start with this, my lord. It will be PDF page 40.
Yes.
PDF page 40.
Yes.
Yes. Now, my lords, I am in item 501.9. I represent Mr. Manglesh Chaube, a serving judge, my lords, enrolled at the bar in 2008, joins as Civil Judge Junior Division 2011. Promoted, my lords, to the cadre of Civil Judge Senior in 2016. What is important, my lords, is Mr. Chaube files a petition before the Supreme Court to appear in direct recruitment examinations for Delhi, Gujarat, etc., my lords. Dheeraj Moore at that point is referred to a larger bench in 2018. Mr. Chaube is granted permission by the Supreme Court to appear for direct recruitment of district judges in Haryana. In 2019, he appears in the direct recruitment exam. The question paper for this exam, he says, is the same as LDCE. He secures second rank, called for viva voce by the Punjab and Haryana High Court. Dheeraj Moore comes out as a judgment, 2027 SCC 401. Mr. Chaube, the petitioner, is disallowed from appearing in the viva for the direct recruitment exam. So, my lords, this is the client that I represent. But with great humility, I also say this, that when I was looking at the figures and statistics on the Ministry of Justice's website, it says this, that there are 25,870 sanctioned posts for the subordinate judiciary in India. Civil Judge Junior 1,000, Civil Judge Senior 6,000, District Judges 8,000 roughly, total strength 25,870. There are 4,789 vacancies. So in many ways, what is before my lords is the stories, the cases, the journeys, the lives, the adjudication of these 25,000 sanctioned posts. So, may it please, my lords. My lords, in 1950, when the Constitution is adopted, and from 46 to 49, during partition, when the Constitution is being written, the framers of our Constitution commit to something very special and specific, which has bearing on, as my Lord Justice Sundaresh said, basic structure also. The Constitution framers committed to an integrated judiciary. What was this integrated judiciary meant to be? My lords, I'll just take you only to 2 documents over the next 15 minutes. One is the Constituent Assembly Debates, volume 4.1, page 942. This was the framers' vision for an integrated judiciary. If I may just take you there, my lords. This is volume 4.1, page 942. Constituent Assembly Debates, volume 7, page 26, 4th November 1948. At that time, this was a very important day, my lords, because this was the first time the framers were sitting in the Constituent Assembly again after the death of Bapu. And a few days before this, Muhammad Ali Jinnah dies across the border. So you'll see on this day, all of that is taken account of. 942. So when I was preparing these submissions, I was very struck by that time. So given that time, you'll see the framers on page 1 start with remembering Bapu, noting that Muhammad Ali Jinnah dies across the border.
So there is a speech by which Dr. Ambedkar presents the draft constitution to the
Yes.
Constitution.
And I have a picture of him in my office presenting the draft constitution to Dr. Rajendra Prasad. And it is the widest smile one could ever see from Dr. Ambedkar. So momentous times, my lords. I will just read this dual integrated judiciary, which is captured in the text of Articles 124, 217, 233, which we are debating 75 years since the Republic came to be. So what my lords are seized of today is a framer's intention, 25,000 sanctioned posts, and the heart of what the common citizen of India first interacts when she comes to court, the subordinate judiciary. What the common citizen of this country faces is a police station and a subordinate judiciary. It is the heart of what is justice in the Republic. Now, please see, my lords, page 942. 3 paragraphs from the bottom in the language of the framers. A dual judiciary, a duality of legal courts, my lords all have it, and a duality of civil services, as I said, are the logical consequences of a dual polity which is inherent in a federation. In the United States, the federal and state judiciary are separate and independent of each other. The Indian Federation, through a dual polity, has no dual judiciary at all. High courts and the Supreme Courts form one single integrated judiciary, having jurisdiction and providing remedies in all cases arising under constitutional law, civil law, or criminal law. This is done to eliminate all diversity in all remedial procedure, Canada, so on and so forth. Now, at the bottom, my lords, the dual polity, which is inherent in a federal system, as I said, is followed in all federations by a dual service. In all federations, there is a federal civil service and a state. My point is this, my lords, in this framework of the kind of a constitution that speaks to a unitary form with federal characteristics, the judiciary is intended to be an integrated judiciary. When we read 233, we must necessarily, to give expression to the framers, read 124 and 217 as a cohesive whole, harmoniously interpreting these textual provisions which constitute one single chapter known as the judiciary in the Constitution of India. That is the first submission. Now 124, 217 and 233. Now 124 and 217.
Why not 235?
Also, my lords, also 235. I bow down to my lord, the Chief Justice. Also. Now, my lords, if your lordship sees, and I'm not going to read it because my colleague, Mr. Shankar Narayan, read the provisions to my lords before me. But when you see explanation 2 of 124.3 and explanation AA to 217.2, and this is all in my submissions, my lords, bar experience and judicial experience are treated as equivalent. It is the same stream, 2 rivers flowing into the ocean. I am asking that that constitutional ocean also be extended to 233, because that is the concept of an integrated judiciary. To do otherwise would not only impact the framers' vision of an integrated judiciary, but also the nature, the character of the Indian state, which unlike America has never been constituted or imagined to be federal, state, different. So if you, in the United States, every state has a state Supreme Court, which is magnum opus, my lords, in many areas. The federal Supreme Court only hears a select few cases. So that is not the conception here. So in this integrated judiciary, my respectful prayer number 1 would be, my lords, this is a composite judiciary. Please read these 3 articles of the Constitution harmoniously. And that is my first submission, my lords, in my written submissions. And a perfect example of this is when your lordships were seized with P. Ramakrishna Raju versus Union of India. This is 2014 12 SCC, page 20. And this is in volume 3, page 1203.
P. Ramakrishna Raju.
P. Ramakrishna Raju versus Union of India, 2014.
1 minute.
Yes, my lords. I apologize, my lords. Volume 5.3, my lords. Judgments 1203, 1196, the judgment starts, my lords. Page 1196, volume 5.3. Paragraphs 19 and 20, my lords. I'll just read them to you.
1196.
Paragraphs 19 and 20. Yes. And the issue, my lords, is the purpose of drawing maximum pension. Could High Court judges appointed through the bar be allowed to count their 10 years of practice? A beautiful example. I'm sorry, my lords. My lord.
It's page 1196. The citation is 2014, volume 12, SCC.
Yes, my
But
lords.
the name
Page
of the-
1, my lords.
The name of the judge is N.V. Ramanna.
No, my lords. Your lordship has 1196, my lord.
Yes.
P. Ramakrishna Raju versus Union of India.
Justice Sadasivan.
Yes, my lords.
Second Bogue and Ramana.
Yes, my lords.
Ramanna sir was a judge in 2014.
PDF 420.
It's okay.
It's volume Roman 5.3. No, my lord Justice Sharma, this is it's a problem both ways. Both ways. Yesterday I was stuck in court just moving my iPad, pushing the papers along because it's difficult this way and difficult that way, my lords. It's a problem.
PDF 420. I got a hard copy.
My lord Justice Sharma has the...
Trying to find it out. It's okay.
Grateful. Grateful. So the issue here, my lords, is where for the purpose of drawing maximum pension, High Court judges appointed through the bar were actually allowed to count their 10 years of service. This was the question before my lords then. My lords, judgment written by Justice Satasivam. Now may I take you straight away to paragraph 19 and 20. My lords all have that. And this would be page 1203 of the compilation.
Para?
19, my lords. May I read, my lords?
Yes.
When persons who occupied the constitutional office of judge, High Court retire, there should not be any discrimination with regard to the fixation of their pension. Irrespective of the source from where judges are drawn, they must be paid the same pension just as they were paid same salary and allowances and perks as serving judges. Only practicing advocates who have gained eminence are invited to accept judgeship of the High Court. Because of the status of the court of the office of a High Court judge, the responsibilities and duties attached to the office, hardly any advocate of distinction declines the offer. Though it may be a great financial sacrifice to a successful lawyer to accept judgeship, it is the desire to serve the society and the high prestige attached to the office and respect the office commands that propel a successful lawyer to accept judgeship. The experience, my lords, the next page, the experience and knowledge gained by a successful lawyer at the bar can never be considered to be less important from any point of view vis-a-vis the experience gained by a judicial officer. If the service of a judicial officer is counted for fixation of pension, there can be no valid reason why the experience at the bar cannot be treated as equivalent for the same purpose. Fixation of higher pension to judges drawn from the subordinate judiciary who have served for a shorter time in contradiction to judges drawn from the bar who serve for a longer time with less pension is highly discriminatory and breach of Article 14 of the Constitution. Classification is unreasonable. So here, my lords, in fact, it's the flip. But the idea is the same. Two rivers coming to the ocean, treat both those journeys with equal respect, dignity, and therefore satisfy.
Both Allahabad and Yamuna and
My lord. My lord. My lord.
Okay.
My lords, my next point, my lords, and this is point 2, and I'll hand over this overview when I'm finished, my lords. My submissions are also there. Is by your lordship's judgment in All India Judges Association 2025, which has been dealt with multiple times, 3 years practice has become now mandatory, my lords, before one assumes the post. My Lord Justice Sundaresh's Jr. also did this, my lords, and we heard the story yesterday, my lords. Following this 2025 judgment, my lords, the theory of separateness of the streams of legal experience no longer holds good. And this is a very simple but important point, my lords, that all candidates now will have a composite mix of experience in the judicial services and at the bar. So, Dheeraj More, which excludes judges from representation in 233(2), doesn't absorb the reality of what is judicial practice today in 2025, given my lord's judgment in All India Judges Association. And respectfully, my lords, any interpretation that restricts eligibility for direct recruitment to only those with exclusive and continuous bar experience only results in forcing those who enter judicial services to erase their own prior bar experience from professional records. It's a very simple point, my lords. I will not trouble my lords with the case. Now, my lords, the third idea is very simply this, that you cannot treat unequals equally. A flip part but important composition of Article 14. In this case, for instance, my lord, because I represent the client, he enters the judicial profession in 2011. He enters the bar at 2008. If he stands excluded, and this is an example, I'm not belaboring his case, this is just an example. If he stands excluded under 233(2), then he is treated the same as a fresher in the profession who clears the judicial services in the same batch, till All India Judges. So there will be these cases also, my lords, which applied before All India Judges.
How is the unequal being treated equally in this case?
My lords, there are two categories here, my lords. Here, because in everything prior to All India Judges, you had those members of the bench, the subordinate judiciary, who may have practiced for 3 years, 4 years, 5 years, as is the case with the client that I have, but then enters the subordinate judiciary. And at that time, when he took the exam in 2012, All India Judges 2025 was not the norm. So his experience at the bar is being excluded, my lords. That's the only submission I have.
Statutory interpretation. Yeah.
Yes, yes, but
probably you can contend that any interpretation which might have a bearing on Article 14 can never be infused into understanding of the Constitution.
Yes, my lords.
That
yes,
is better.
And also, my lords, that the Constitution, as it is a living, growing document,
Organic document.
It's an organic Constitution. It has to be infused with the dynamism that it demands, my lords, and that this country demands. In fact, my lords, I was very struck. 1.3 billion people, 25,000 sanctioned judicial posts. We are surely one of the most under-judged countries in the world, my lords. Because I actually went through the figures, and the figures, in fact, break it down by gender, by caste, by ability, and the numbers are very few. And for 4,000 vacancies, so 22% vacancies in this 25,000 sanctioned posts. We need to make these posts more attractive, my lords. One way of making them attractive is to make them equal access, but equal outcomes also.
Counter argument would be that if you permit this, then there will be many vacancies in the cadre of civil judge junior division and senior division.
No, my lords, these sanctioned posts are civil judge junior and
Using of the subordinate judiciary.
yes, subordinate judiciary, my lords.
You are arguing this. If you permit the civil judges, senior division and senior division, then all those posts would have fall vacant and the number of vacancies would further increase.
No, my lords, the civil judge junior division is 1,000 of these 25,000 posts, and civil judges 6,000.
That once you permit civil judges to take the exam,
Yes,
people
will join the judiciary, and you won't have these 4,000 vacancies, my lords.
Recruitment process for filling of a civil judge junior division is comparatively easy than filling up the post of a district judge, where
Yes.
you require at most scrutiny here.
Yes, but my lords,
That's the reason why the Constitution consciously includes the Service Commission of the state
yes.
in consultation with the High Court there. Here it's a different ballgame there.
And my lords, the idea is to make that civil judge junior post attractive.
So to fill up the civil judge junior division, we could do it with the consummate ease. When it comes to the district judiciary, the higher judiciary, as in fact, which you are dealing with, it's a very, very difficult, laborious task. So,
my lords, if you see the recruitment exams in a place like Delhi, because this is very interesting, many young lawyers take those judicial services exams. because Delhi is seen to be an attractive posting for a judge. There's good infrastructure, so on and so forth.
Delhi should not be the benchmark.
No, my lords, I'm only speaking of Delhi because for the first time, you have the numbers applying have changed. The numbers applying have changed. The composition of who applies has also changed, my Lord Justice Kumar. Yes, my lords, I will now bring myself back. My lords, the next point I want to make. No, my lords, nothing is a waste when I'm hearing from my lords.
You already exceeded your time because we have to hear all.
My lords, then I will finish in the next 2 minutes.
Yeah.
2 minutes. My lords, inter se cadre seniority amongst district judges, my lords. The last point I'd want to make, my lords, is simply this, that when we negate those years at the bar, then inter se between the judiciary and the district judges, there also becomes an unevenness. Because you have some who have pre the 2025 judgment entered with legal experience, advocacy experience, and some who don't. And then that seniority between them is also rendered fraught. My lords, the last point I want to make.
That's not an issue before us.
My lords, it's something that I have dealt with in my written submissions.
That issue is pending in All India.
Yes.
Case, but that's a different issue.
Yes, but my lords, this inter se seniority issue, I would request your lordship to consider.
That's not a question before us. Inter se seniority between the promotees and direct recruit.
My lords, it's also about how do we incentivize young people to take these exams.
Answer the question.
My lords, the answer to this question is that I am only trying to...
We are here only to answer the question which are referred to us.
Yes.
We can't go beyond the reference.
No, this is as an issue which comes up today with the subordinate judiciary. That's my only point.
That's not an issue for consideration before us.
Very well, my lords. And lastly, my lords, I'll just say this, that we would want to facilitate and enhance access to justice and access to effective legal remedies. And one part of that is to ensure the best candidates are judges at the subordinate judiciary. Grateful, my lords. Grateful.
My lord, I am in 5011, item 1. This is a writ petition, my lord, where the candidate before your lordship, Dr. Mandeep Mittal, was granted permission to appear and has been 5011. Dr. Mandeep Mittal was allowed to appear, was selected, and he's working for the last 6 years as a additional district judge in Punjab. He has 4 years experience before that. I have nothing more to say. I have to adopt all the arguments. Everything is there, except not one small addendum to what Ms. Guruswamy said. If your lordship has an opportunity to look at the entire system of promotion, appointments, etc., this extreme stagnation which is taking place in the judiciary from magistrates to additional is dissuading a lot of people from joining. There's an extreme stagnation from being a magistrate up to the additional district judge. So this is something that may take care of it. If they are allowed to participate, this is one measure that may take the interpretation. I'm not saying that this could be the reason for 233(2), but this can be a factor that can persuade your lordship. I have nothing more to say. Guys.
Thank you. Very, very precise and very brief.
Lord, I had just suggested to them that all those who just want to go in and out should have been given the opportunity in the morning. Who have not, because most of it has been said yesterday, actually. We are just repeating it and it's just wasting. I won't say wasting, Lord. Some of them will, I'll have a protest on my hands outside.
Yeah, all of you are enlightening us. That's all I will say.
To whatever extent we can.
Please, my lord. I appear for Avinash Kumar, my lord, who is a respondent number 2 in 501.15. His intervention was initially allowed, my lord, and therefore again he filed a IA 227875 of 2025, my lord. Now, my lord, he joined bar in 2006. He was appointed as a civil judge.
What number?
2 in, my lord. Now, my lord.
Point 15.
15, there is more. Now, my lord, he joined bar in 2006. On 23/4/18, he was appointed as civil judge. my lord, he was allowed to, he took a permission from the High Court and he was allowed to participate, my lord, in the higher judicial service. And thereafter, he cleared the written exams, but because of Dheeraj More, he was not allowed to participate in the Viva Voce. Now, my lord, Dheeraj More requires consideration on 4 counts, my lord, because of 4 reasons. One, it compartmentalized 233(1) and 2. Second, my lord, that there is a negative stipulation which is provided. Third, the reading of phrase has been, my lord, as perfect continuous tense. And the fourth, my lord, that there is a quota for advocates. Now, my lord, may kindly have 233 once again, my lord. The Constitution. My lord, 233, my lord, how it has been dealt with in Dheeraj More, my lord. Dheeraj More reads 233(1) as, my lord, appointment by way of posting and promotion. Now, what it provides, my lord, in para 12, it holds.
Brother said that appointments by.
My lord, may kindly Dheeraj More, my lord.
Appointments, postings and promotion.
And promotion. And promotion, my lord. And that's why it holds that 1 deals with promotion, posting and promotion, and 2 deals with direct recruitment from the bar. Now, my lord, may kindly have this reading of promotion. In fact, in the provision, it is, clause 1 says, appointment of persons to be and the posting and promotion of. Now, what Dheeraj More does is, my lord, it reads it as promotion to, which cannot be, because it presumes that insofar as the promotion is concerned of district judge, that would be taken care of in 2217. So this has to be promotion 2, my lord, which was not the case when it was adopted. My lord, the Constitution Assembly debates are very clear, and they were very conscious of this fact. My lord, the framers were very conscious of the fact that this would create confusion, and therefore, my lord, we kindly have the Constitution Assembly debates, my lord. This is CV volume 4, my lord, page 259. At 264. But 263, my lord.
Volume.
CV volume 4. 4.1.
Yes, page number.
Page number 263.
2.1 short.
It begins from 776.
The one I had read yesterday was page 3,
Where are the
which had all the previous, the government of India Act 1915.
Which volume, sir? 4A.
My lord, 263, my lord.
Yes.
Yes.
Now, my lord, 263, Pandit Hridayanath Kujuru. The object of my amendment Lord, got it?
Yes.
The object of my amendment is to allow high courts to be responsible for transfer and promotion of district judges in the same manner as they will be for the transfer and promotion of subordinate judges and other subordinate judicial officers. My amendment do not touch the question of appointment. The governor will appoint district judges in consultation with high court. All that I desire is that the district judges, after their appointment by governor, should be under the control of high court. I have, for my amendment, the authority is no less than a person than a chairman of the drafting committee, my honorable friend, Dr. Ambedkar. Now, my lord, it was inter se cadre because, my lord, earlier the district judges,
Yes.
had assistant district judges, my lord. It was the inter se promotion. And, my lord, if we historically look at the how 233(1) was adopted, my lord, it was the framers adopted broadly.
Yes.
Framers adopted broadly the wordings of 254(1), my lord. And in fact, the control from governor was given to the High Court. So this anomaly, my lord, which exists and which is read repeatedly, is because the courts have read this promotion of as promotion to.
This amendment has been negative.
Yes.
But why? What was the reason, my lord? What was the backdrop?
Yeah, but then Dr. Ambedkar has.
But, my lord, insofar as of is,
Article 50 is very much there in the Constitution.
please, my lord.
We need to go to all this.
My lord, of.
Article 50 specifically
Lord,
provides for separation of powers.
My respective submission is that of cannot be read as to. That's why, and my lord, may kindly have the historical background. Why it was provided? Because the powers which are vested in High Court by virtue of 233 are far wider power of adopting rules, framing rules for appointment of the district judges. In so far as, and therefore, my lord, Chandramohan, as it holds, that to provide for two sources. 233 provide for the sources, one provide for is a declaration giving
That's
power.
already been argued.
It has been argued, my lord. Now, my lord, kindly have my written submission, my lord. Just volume 1.
Tell us what, rather than reading, you tell us what are your submissions, we'll record this.
No, my lord, one thing no, my lord, if there is no bar, my lord, if there is no bar which is provided under the Constitution, it cannot be read in. Now, my lord, there is a bar which is being read in by Dheeraj Moore, my lord. Now, Manoj Narula, my lord, which is at volume 3, 778, paragraph 52, specifically provides, my lord, which holds that on a studied scrutiny of ratio of the aforesaid decision, we are of the convinced opinion that when there is no disqualification for a person against whom charges have been framed in respect of heinous or serious offences or offences related to corruption to contest the election by interpreting the provision, it is difficult to read the prohibition into Article 75(1) or for that matter into Article 164(1) to power of the Prime Minister or the Chief Minister in such a manner that would come within the criteria of eligibility and would amount to prescribing an eligibility, qualification and adding a disqualification which has not been stipulated in the Constitution. In the absence of any constitutional prohibition or statutory embargo, such disqualification, in our considered opinion, cannot be read into Article 75(1) of Article 164(1). Now, my lord, this honorable court, my lord, as my lord, the present reference is made under 145 of the Constitution of India, my lord.
Yes, thank you, Mr. Ghosh.
All right.
My lord, I beg to appear in item 501.18. Lord, most of the arguments, in fact, everything has been covered. I just wanted to show, my lord, how textually Article 233(2) appears if we look at the Dheeraj Moore judgment, my lord. I've just prepared a comparative table. Lord, may kindly see how the article appears. On the left-hand side is the original text of the article. And on the right-hand side, if we take the Dheeraj Moore interpretation, then what will be the Lord? So what I have done, I have introduced the words as per the judgments in the bold and striked off the words which have been now read into. Lord, may kindly see the right-hand side.
You are in which number?
501.18, Lord. Lord, he was a lawyer for 3 years. He qualified for the judicial services. He became a judicial magistrate, continued for 9 years as judicial magistrate. Then he got selected in the Delhi Higher Judicial Services exam. Lord, may kindly see. Yes, Director. Lord, now as per Dheeraj Moore, it reads like this. Only a person not already in service of the union or the state shall be eligible to be appointed a district judge through direct recruitment, provided he has been for not less than 7 years an advocate or a pleader is recommended by the High Court. Lord, clear violence to the text of the Constitution. 2. Lord, the Chandramohan interpreted word services as judicial services based on the text of Article 50. And now, my Lord, also post Keshwanand Bharti based on the basic structure, because there has to be separation. But here there is a complete new text which is read into 1, 2. My Lord, the Rameshwar Dayal and Chandramohan both says that the 233(2) provides for 2 streams. Now, because of this introduction of word only in the beginning, now only 1 stream is provided. Lord, I adopt rest of the argument.
Thank you very much.
Deeply obliged.
Brief and precise, like Mr. Valla.
Deeply.
Lords, I have been requested by the Maharashtra Judicial Officers Association to assist your lordships. I'll just take few minutes. We have submitted a formal application for intervention. Orders may be just passed if required. My Lord, I adopt the arguments on the interpretations of Article 233 that subclass 2 therein is only for the prescription of eligibility in respect of the advocates who are competing in the nomination process, appointment by nomination process. That is only the limited scope prescribing eligibility criteria, and that article cannot be read beyond anything there.
Providing a quota.
Provided. Quota is not provided there. Quota has come by way of judgments of your Lordship Court adopting Shetty Commission recommendation.
All India judges, 1.
1. And the 2002 judgment adopting the Shetty Commission recommendations of 25%.
But then the commission reports have not been properly considered even in that judgment.
I'm coming to that. My Lord, the origin of Article 233 is the 1935 Act, that is Section 254.
1915 and then 1935.
1935 Act, Government of India Act, 1935.
And then 1935.
1935 Act of Government of India, Section 254. And not the earlier rules. Earlier rules give some benefit of doubt to say that, look, there is sort of compartmentalization. That Mr. Bhushan has referred to the earlier rules of 1922 also. But the origin of 233 is in 254 of 1935 Act. Well, despite the 2 judgments, Constitution bench judgments of your Lordship's Court, that is Rameshwar Dayal and Saikia's case, the high courts on their administrative side all over the country believed that there are 2 different streams for appointment of district judges. One is by promotion, the other is by nomination. And so far as nomination is concerned, only advocates are entitled. This was the belief which prevailed till a judicial debate started in the case of Satyanarayana, which Mr. Singhvi just now cited before your Lordships, that whether the judicial officer should be allowed to compete in the selection by nomination process. That was for the first time. And the Shetty Commission took note of this. And therefore, in its report, which Mr. Bhushan referred to, and it reflects in the judgment also of 2002, that Shetty Commission specifically recommended that the judicial officer should be allowed to participate in the process of appointment of district judges by nomination. Your Lordship's court, for whatever reasons, remained silent, did not give any reasons.
Did not even say that.
Yes.
Though it is silent, but the first judgment also does not say that the in-service candidate would not be eligible for that.
It does not say.
So
Nowhere by judicial order, your Lordship's court has said
it only
that they are not
specifies
entitled.
25, 25 and 50 quota.
Yes.
But doesn't restrict the judicial officers to courts.
No, it does not specifically, but the recommendation is not accepted. Now what happened, my lord, because of the judgment of 2002, all the high courts were directed to amend their service rules and fall in line with the judgment. As a result, now that quota of 50%, 25% and 25% came. Now, therefore, it is clear that if a judicial officer has to become a district judge, he is told that, look, there is a feeder cadre, namely civil judge senior division. Unless you are there, you are not eligible to compete as far as promotion process is concerned. Now, for the 25% quota, the high courts framed the rules and specifically barred the judicial officers. For example, I will place before your Lordship, just for reference, Bombay High Court, Maharashtra service rules framed by the Bombay.
That must be based upon the more.
Pardon me?
That must be based upon the.
No. Shetty Commission
All
recommendation
India,
following that.
all India judicial officers want.
Rules were directed to be framed.
Yes.
We'll take it away, They also pointed out.
In Uttar Pradesh
Some other states also it is built.
Yes. Your Lordship just sees Rule 7.
Karnataka has also said that he said, they have
Almost.
What is giving you must give us.
Almost all the high courts updated their rules.
What is this?
Please come to page 5 of this. Page 4 is recruitment of district judges, Rule 4 and 5. And if your Lordship comes to page 5, that 25%. See, 25% of the post shall be filled by nomination from amongst the eligible person practicing as advocates on the basis of a written and viva test conducted by the High Court. Now, on the right-hand side column, what my Lord the Chief Justice said yesterday, experience must be practicing as an advocate in the High Court or court subordinate thereto for not less than 7 years on the date of publication of the advertisement, and while computing the period of practicing as an advocate, the period during which he has held the post of public prosecutor or government advocate or judicial officer shall be included, or must be working or must have worked as a public prosecutor or government advocate for not less than 7 years in the post or post on the date of publication of the advertisement, and while computing the period of service, the period during which the candidate has practiced as an advocate shall be included. So there was a specific indirectly bar for any judicial officer to compete in the process of appointment by nomination.
No, but must be practicing as an advocate in the High Court or court subordinate thereto for not less than 7 years on the date of publication of the address, and while computing. So this bold.
Judicial officer is not there.
But why it is there? Or shall be included? It is there, included.
While computing the period of practicing as advocate.
So this is a bold you want to introduce, or it is already there?
Remember, my lord, when he was a member, but for suppose 2-3 years, he had worked as a judge and then resumed practice. In those cases, this applies. Suppose there was a candidate who joined the judiciary, resigned, and then yes, that period also has to be counted. That is something like.
So that can be counted. So suppose if he resigns.
Yes, this is counted.
It is counted.
Yes, but sitting judge, no. That is what happened.
We are not going to the rules of each case.
I am just giving the historical.
No, that's a great. That's why you are here.
What happened? This is what happened.
That is the reason why you are here now.
Therefore, now Therefore, my lord, there is no specific law in the constitution. But
वही 2010 में आया है.
अच्छा, okay. I'm sorry.
Now, whether the High Court has amended in accordance with Dheeraj Moore?
not yet.
It has not been amended so far.
My lord,
It has not been amended so far.
so far, to my knowledge, no. I do
That's
not
not
know
possible.
because I read the High Court's affidavit also. Bombay High Court has filed an affidavit. They do not refer to the, but they refer to the judgment of Moore and say that whatever has been held there is correct law and the judicial officers should not be allowed to
This
compete.
is contrary to the stand they had taken before the Shetty Commission. The Bombay High Court in the
Yes.
Shetty Commission submitted that the judicial officers should be permitted to compete
Yes.
against that
Yes.
quota. That will enhance the quality
Yes.
of the judicial administration and all that.
Allahabad also, Bombay also.
Bombay also.
And as a matter of fact, Shetty Commission has appreciated the stand taken by the Bombay High Court.
But Bombay High Court has filed an affidavit and I said that
You know,
whatever is decided
Yeah,
by.
obviously, for the reason,
you know how these
just
affidavits
for
are
us
filed.
come. See, as a High Court, you're supposed to follow the Supreme Court. The right or wrong is indifferent.
Yes,
different
yes,
issue.
yeah. We know how the affidavits are filed. That is for a larger debate. So let us not get into that. So I adopt the arguments and say that, look, there is no prohibition.
Thank you.
And it has to be read as it is. And the judicial officers are entitled. My lord, I may also say that any judicial.
That's correct. That's what this is the point to know. Yes.
Just one line. Any judicial officer, whether he is in junior division or senior division.
That goes without saying, nobody's saying. It's not a promotion.
Yes, I don't wish to take your lordship.
Thank you.
Thank you.
Yes, without.
Please, Lordships. Lord, I am appearing in this IA, which is listed at serial number 5 in the today's office report. Lord, my case is that I appear for Dr. Karuna Sharma, who was enrolled as a lawyer in 2005. Then, my Lord, she joins as a judicial magistrate in December 2013. Then, my Lord, because I had more than 7 years of practice as a lawyer when I joined service. Then, Lord, in 2015, Punjab and Haryana High Court advertises 6 posts of additional district and session judge. Because, Lord, the Punjab and Haryana High Court did not debar it. Anyhow, after this advertisement dated 16th of July 15, Vijay Mishra judgment came on 9th of August 2016, which said if you are you have requisite experience of 7 years as a lawyer, then 233 will not debar you from becoming eligible, because the ratio says that you can selection is different from appointment. 233 doesn't debar you from applying and participating in the selection process. When it comes to appointment, you can always seek an resign and seek an appointment. So, the governing law of the land as on 17th of August 2016 was Vijay Mishra. Punjab and Haryana High Court issues a corrigendum in line with Vijay Mishra. So, I, as eligible candidate, applies for appointment. Out of the 6 posts, I became the topper. And ultimately, because this selection process and the corrigendum by Punjab and Haryana High Court in line with Vijay Mishra, one writ petition came to be filed challenging the corrigendum by the High Court in line with Vijay Mishra. And that writ petition was in 2017 by one Anmol Nair. Writ petition was dismissed by saying that the corrigendum is in line with the law laid down by Honorable Apex Court at that point of time. I came to be appointed as ADJ on December 2018. In the meantime, this Anmol Nair had come to this Honorable Court. No stay was granted. SLP remained pending because simultaneously Dheeraj Moore was also pending. Ultimately, Dheeraj Moore says Vijay Mishra is a bad law. And now, I want to invite kind attention to the concluding para of Dheeraj Moore, how this Honorable Court has dealt with the cases where the appointments happened pursuant to the interim orders passed by this Honorable Court. Lord, may kindly permit me to go to para 47 of Dheeraj Moore. Lord, this is volume 3, page 1005. Just, Lord,
SCB, so Punjabi's compilation. So
It is in the CB compilation, my lord, page 110 is relevant para, my lord, I want to.
paragraph you want to refer to?
Para 47 and 48, but just the Roman 6 of para 47. My lord, has it?
Yes.
Para 47, Roman 6.
There is no Roman 6.
Point 6. This is, my lord, para 0.6, my lord, 0.6. In my case, it's shown Roman. The decision in Vijay Mishra, my lord, God.
Yes.
The decision in Vijay Kumar Mishra providing eligibility of judicial officers to compete as against the post of district judge by way of direct recruitment cannot be said to be laying down the correct law correctly. Same is overruled. Now, my lord, may kindly see the next para is important. How these appointments have been dealt with. In the case of Dheeraj More and other cases, time to time interim orders have been passed by this court, and incumbents in judicial service were permitted to appear in the examination. Though later on this court vacated the said interim orders, by that time certain appointments had been made in some of the states, and in some of the states results have been withheld by the High Court owing to the complications which have arisen due to participation of ineligible in-service candidates as against the post reserved for the practicing advocates. In cases where such in-service incumbents have been appointed by way of direct recruitment from the bar, as we find no merit in the petition, and due to dismissal of the writ petitions filed by the judicial officers, as a sequel, no fruit can be ripened on the basis of selection without eligibility. They cannot continue as district judges. They have to be reverted to their original post. In case they are right in channel, that's not relevant. The point I'm making is this. My lord, in para 48, this honorable court in Dheeraj More says, because you participated in the selection process pursuant to the interim orders we have passed in here. In some cases, interim order continued. You, because of the interim order, you participated in the selection process. You might have been even appointed. And in some cases, the interim orders were vacated. And hence, because ultimately the writ petitions are being dismissed, so you cannot, the benefit you got pursuant to the interim orders cannot inure to your benefit. My lord, the category of cases probably were not brought to the notice of this honorable court, like the one I am representing.
We are not deciding indeed.
My lord, what I am submitting is Dheeraj More need to be clarified. My lord, if assuming, my lord, assuming against myself that Dheeraj More is upheld by this honorable court, still, my lord, the people who got appointed.
That is not that is for that the independent petitions will be decided by the benches.
My lord, because my lord, it is in view of Dheeraj More. They have reverted me subsequently in 2020, saying that Dheeraj More has decided. Now you have to be reverted. My lord, I was appointed when Vijay Mishra was governing the field.
We are not deciding an individual petition.
That's
whatever we lay down herein, the concerned benches will decide on the basis of the law laid down.
Only, Lord, just two respectful submission. One is, Lord, may consider clarifying it that the people who were appointed.
That's not a question before us. We have framed particular questions.
I bow down.
They will be answered, and whatever is answered, the benches will decide the independence in accordance with the answer.
So, Lord, that clarifies. Just one thing otherwise on merit, Lord. While interpreting 233, Lord, Vijay Mishra, in my humble submission, judgment is consistent with the Article 14 and 16 of the Constitution of India. Because, my lord, merely because, my lord, this is an appointment for the post of district judge. And I may be ineligible to apply because I do not have a 7 years experience as a lawyer, which is prescribed. But if I am eligible as a lawyer prior to joining the service as a judge, I becoming disqualified only on account of the fact that I am already a judge.
That has already been argued by.
That's right. That's right. So, my lord, this is all.
Thank you. Thank you. Yes, Mr. Murali.
May I please, Lordships. I'm in 501.3, Your Lordships, and RP number 381 of 21. My written submissions are in volume 1, page 55. In fact, the petitioner number 1 became an advocate in 2000. He got appointed in
Yeah,
2014.
even serial number
Serial number 501.3, Your Lordships.
501.3.
My written submissions are in volume 1, say at page 55, Your Lordships. I primarily represent 3 judicial officers, Your Lordships. Petitioner number 2 got enrolled as an advocate in 2000. He got selected to the as a civil judge in 2014. As on the date of his appointment, in fact, he had completed 13 years, 5 months, Your Lordships. As regards petitioner number 2 is concerned, he got enrolled as an advocate in 2002. He got appointed as a civil judge in 2014. He had about 11 years experience. And as regards petition number 3 is concerned, she got enrolled in 2005 and got appointed as a
We
civil
are not
judge.
going into the individual facts.
Please, Your Lordships. Primarily, all the 3 of them.
Consistently that the individual matters will be decided after the reference is answered.
Please, Your Lordships. Primarily, in fact, all the 3 had, let's say, more than 7 years, more than 10 years plus of experience.
Not going into the facts.
Anyways, there's not much to argue because it's all been covered, Your Lordships. In fact, I had only one point that is there as regards prospective overruling, Your Lordships. In fact, my Lordships may have, let's say, the written submissions that's there.
Paragraph 10.
Please, Your Lordships.
10.
Paragraph 10, Your Lordships. Even presuming for a moment, in fact, let's say if Your Lordships were to actually hold that Dheeraj More holds the field also. As on date, okay, Vijay Mishra was the law in 2018 when I made my applications, where in fact I cleared my vivos, I cleared, let's say, my prelims, mains, and vivos C. Now it's only primarily, let's say, in the order, let's say, the interim order, let's say, in Dheeraj More in 2018 for the first time when I used to be appointed. In fact, let's say, appointments would be given. In fact, it actually said that you will not be entitled to. In fact, what my learned friend actually read in paragraph number 48.
Not going into individual cases, they will be decided on their own merit.
Yes.
Please, Lordship. In fact, okay, there's one judgment wherein, say, I had a legitimate expectation. Now, in fact, please, Lordship, I rest my case. In fact, otherwise, let's say, I believe it's all covered.
I appear in item 50.19. Lord, I appear in item 50.
Lordship, I have to bring in your notice the injustice created by the nodal counsel. Nodal counsel is not allowed to decide whether the advocated record would not argue in this court if the senior counsel is not engaged. He is taking the space of this court. I have filed my written submission timely, but he intends.
What do you want to argue? Tell us, what do you want to argue?
Lord,
Let him argue.
Lord, I am appearing in item.
Let him argue, so he is so anxious.
Quick, Mr.
He is so anxious for letting argue.
He has to be there in every costume.
Lordship, I am appearing for the item number
Lordship,
501.
His written submissions, page 113. No, that's something seriousness has to be there. Page 113 of the compilation 1 is the written submissions of Dr.
Yeah,
Lordship,
absolutely.
can you see that?
Lordship, can I start?
Achha, then your submissions are good enough. We'll look into it. It says the cases should be decided
according to the constitution and law.
Because Lordship, at the last point we have to.
I'm not finished. We'll do that only. Better ends.
Lordship, can I say one thing?
Your prayer is, please decide the matter as per the constitutional provisions. I'm assuring you, again and again, we'll do that.
Lordship, we have to explain what is left at the last. So that's why we have.
After so many years of practice, I mean, you mean to say we don't follow the Constitution of India?
Yes, all those who are want to say something, they can give.
Lordship, I will explain totally new points if you allow me.
Thank you.
Lord,
We have seen your submissions, we will decide according to your submissions.
Lord, I appear in item 501.19. Mr. Shoaib Alam, senior advocate, had to argue this matter, my lord, but I'm sorry he is not available. With some difficulty, my lord. That's why may I just make a small point? It will not take much more than a minute.
Yes, what do you want to ask?
Yes, my point is this, that as far as Article 233 is concerned, it starts with appointment of persons to be. The first part deals mainly with the judicial officers. And as far as the second part is concerned, it starts with a person who is not in the service of the union or state. So first part deals with the judicial officer. The second part deals with somebody who is not in the service of the union or who is not a judicial officer, for them, the qualification
That
prescribed.
is already argued, yes.
Yes, my lord. As far as the facts of my.
Facts we are not deciding, yes.
My lord, I have already completed 7 years of practice before joining the Bihar subordinate judicial service. Thereafter, the advertisement came, and as per the advertisement, I had.
We are not deciding the individual cases.
So I'm just on a small point, and that point was.
Mr. Shan, please don't embarrass the court like this.
I'm so.
By arguing contrary to the constitutional judgment.
I'm so.
Lordship permission, my lord, I'm appearing in 501.8, the Kerala batch of cases. What is left out, Mr. Naidu has argued about that. I'm representing those judicial officers, those who are in them. My lord, one small submission in this.
You don't permit more than one person to argue in
One small submission.
party.
That's it, my lord. Because post Chandramohan, my lord, there is a constitutional amendment which has been taken place, 233A. There is also the rule of 7 years has been categorically specified in that. This has not brought to your notice, my lord. So I just wanted to mention that aspect. Second aspect is, my lord, in Chandra Mohan, the definition given to the service is also incorrect because 236 very categorically, 236B, my lord, defines the judicial service. So the definition which has been extended to exclude the judicial magistrates is incorrect in my opinion. To that extent, my lordship has to distinguish Chandra Mohan. Rest all the submissions, my lord, I'm adopting.
So we want to refer to larger bench.
No, my lord, I'm not saying that it need to be. I'm not saying that, my lord, because that situation demanded that.
We are quite conscious of it. That is the reason why cynicals also they are not gone into that.
And
therefore we are proceeding on the footing.
233 amendment.
We understand different between 233 and 234. 235 on one hand, you want to say they won't say judicial service, others say merely service. Got it? We understand.
That's one thing, well, and 33A, the amendment 7-year rule has been reiterated.
Don't cause more damage to your own client. Thank you.
Deeply. My clients are all having 7.
My lord, I am appearing 0.23, my lord. I am sorry I did not get chance to be included in that list, my lord. I have prepared a written submission, my lord. I want to.
What do you want to say? You tell us.
Yes, my lord, just 2 things, my lord, apart from submitting these.
Forget about what. Tell us what you want to say.
My lord, first thing, my lord, this advocate quota is not by way of affirmative action, my lord. This was not embedded in the constitution, my lord.
Yes.
If this is read as contradistinction to the service quota, my lord, this will be read as open quota, my lord. And if it is read as open quota, everyone will be included, my lord.
Yes.
And this will cast the net wider, my lord. Why I am saying that, my lord? Even in Bar Council rules of 1975. Just one part, my lord. That part-time teaching,
etc. What is right, what is wrong, which is we are not even. The Honorable Chief has already said a number of times. We are not deciding yet. It's not a rule or
no,
act.
Just on the principles, my lord. Just to cast net wider, my lord, so that merit is.
That is already
my lord, we have included some quotes from ancient text, my lord. This
not,
may have
not
in writing judgment.
Not disputed.
My lord, I'm appearing 5014. The only fact which I'd like to bring to notice of my lord is that I was competing with the SC quota, my lord, and prior to.
We are not going into the individual matters. How many times we have to tell you the same thing?
My lord, this may be taken.
No,
my lord.
Lordship, I have to reply the Hansaria sir objection
thank
because I was stopped from the argument after his objection. Only 1 minute I will satisfy. He, Lordship, I am not arguing about the matter. I am just very important thing. There is the difference between the written submissions and the argument. Argument includes the logic and the explanation by the advocate and the questions from the bench also, while the written submission only outlines the basic framework in which we have to argue. And he raised the question on my written submission. Lordship, in my written submission, 3 parts. In first, I mentioned the issues. On second, I wrote, they should be responded according to constitutional provisions and law. That means I will speak only on that specific provision which is mentioned in the issues. And third, it is because argument.
Called upon Mr. Singh.
Pardon, Lordship?
We are called upon Mr. Singh to argue. Yes, proceed with it.
Lordship, Hansaria sir objected, so that's why I have to reply. He raised the objection.
Don't force us to make anything unpleasant.
Lordship, I always.
Don't force us to take any unpleasant step.
Lordship, I am grateful, but I have to reply so that objection, so that.
I'm repeating it for the 3rd time. I won't repeat it on the 4th time.
Lordship.
Yes, please.
May it please, Lordship. I appear for in serial number 501 for the respondent, who is the member of the bar in Kerala, who has been selected. She was one, Mr. Rajneesh, who is the petitioner in 501, they're both in a reserved category of other backward classes. He was at number 2 and I was at number 4. In between were open candidates 1 and 3.
You're from the reserved category.
Of other backward, there's a particular community reserved for that. So he was within us, he was number 2 on the select list. I was number 4. 1 and 3 were open general candidates. So between us, he is one position above me. He's a serving member. He was a munsif, serving munsif at the time of this. I've put a list of dates along with my.
We are not doing the facts on the matter.
No, but I'll come to that later. Something will turn on it, and I'll come to it in a moment. I'll be within my allotted time. Your Lordship may take it. Now, the main point, I'm going to just broadly address certain very important issues. Because of the time limitations, I've consulted my learned friend, Mr. Nidesh Gupta, who will be the following batsman. And so far as the finer points with regard to the 2 constitution bench judgments, 1960 and 1965, that is Rameshwar Dayal and Chandramohan, my learned friend would be addressing your Lordship in detail, so I won't go into that in excessive detail. I just want to point out just take your Lordship to one passage in Chandramohan because I'll be developing on that. Broadly, let me just put it before taking my Lords to the main points. Broadly, let me just put it in this way, Lords. The gist of my submissions are going to be, Lords. One is that for the last 60 years or more, the interpretation of Article 233
for the last 60 years,
for 60 or 65 years, the interpretation of Article 233 has been uniform.
Interpretation of
Article 233 of the Constitution has been uniform and has stood the test of time. And what was held in the 2 constitution benches, because there are always certain factual variations in any judgment. Your Lordship may not take it down. I'm just giving a broad overview. What is held in the 2 constitution benches has then been further interpreted and amplified by several 3-judge benches in 1985, 1999. There are others, but mainly 1985, 1999, by which time, my Lords, it was taken as a given that there are 2 distinct sources of recruitment under Article 233.
one being by promotion and the other being by direct recruitment, and that the direct recruitment was only from the source from practicing advocates or practicing members of the bar. This is not today, 1985 in Satyanarayan, 1999 in Sushma Suri, 2002 in All India Judges. This became...
2002 All India Judges doesn't say so. It says that...
I'll make good the point. I don't want to... I'll make good the point. Your Lordship may just... the broad perspective in which I would argue is this, that one can...
Last 60, 65 years, it has been understood that this 25% nomination quota is only for the practicing advocates.
Yes. That became the accepted position as far as your Lordship's court is concerned. And that became beyond cavil. So it was that every judgment starts.
Therefore, what stare decisis?
Yes, absolutely. Your Lordships are right. And I put that in my written submission, and I'll make good the point. This is not the case. This is broadly, the submission is this, that this is not a case where Dheeraj Moore in the 2019 judgment of your Lordships in Dheeraj Moore 2019-2020, that it carved out any new point of law at all or said anything new for all intents and purposes. All it did was reiterate what was said in Satyanarayan, what was said in Sushma Suri, what was said in All India Judges, etc. Earlier 3-judge benches. The only reason a 3-judge bench had to deal with it in Dheeraj Moore was because certain 2-judge benches deviated from the settled law.
Vijay Mishra or Sharma.
Yes, deviated from the settled law. Now, when a learned 2-judges bench does not follow the settled law, then the matter gets referred to 3 judges. But it was not as though Dheeraj Moore was dealing with anything new or some terra incognita or some so to speak virgin territory as far as the interpretation of 233 is concerned. They merely reiterated. So what is being argued by the petitioners, if I can just colloquially use the phrase petitioners and respondents.
It is written there also.
Yeah, it's easier just instead of saying for the proposition against the proposition. What is being argued for the petitioners basically is and that is how your Lordship were persuaded to refer it to a larger bench, is that there's a constitutional issue which was open and where Dheeraj Moore has carved out some new territory. That the 3-judge bench has carved out some new territory, and therefore the court must not revisit the entire issue of what the 5 judges benches said. On stare decisis, my argument is going to be that if the 5 judges benches have been interpreted consistently over a 40-50 year period and followed throughout the nation, in state after state and throughout, and without causing any public harm or any damage to the polity or something, then the principle of stare decisis ought to apply. And that interpretation which has prevailed for 40, 50, 60 years should not be disturbed merely because there may be some slightly different way of looking at it.
For Constitution bench judgment,
yes, Milord,
is wrongly interpreted over the years by 3 judges benches or 2 judges benches.
My Lord.
Can't another Constitution bench not consider the correctness of those 3 bench judgments?
If your Lordships find that there's some startling error.
Please move on to some other point.
I'm sorry.
If we agree with you, then there cannot be development of constitutional law.
No, of course there would be development.
If we accept your argument, Keshavanand Bharati is in Would have been wanted now.
Section, I think.
I was answering what fell from your lordship, no?
Okay.
If unless the court finds that there's some startling error in that interpretation, there's something which is conducive to public mischief, or my lord, which is something which sort of shakes the conscience of the court feels that is some egregious error committed. If not, I'm submitting if there is a consistent interpretation where there may be, that's why I said where there may possibly be a different point of view. That would not be sufficient. That's all I'm saying. I'm not trying to pitch it on a case that if your lordships find even today that the interpretation in Satyanarayan, etc., is egregiously wrong. Yes, of course, your lordships could, nothing to stop the court from correcting itself. The point is whether that is so, and that is why so I was just prefacing it with that. The second aspect which I'm going to place before your lordships is that when statutory rules have been framed under Article 309 vis-a-vis the manner of implementation of two sources of recruitment, then unless your lordship find that those statutory rules are ultra vires the constitution.
Should we refer to the rules for interpreting the constitutional provisions?
No, my lord, I'm sorry. I didn't make my position clear, my lord. I'm not, Lord, this is not a case where it's a sort of cart leading the horse or something. I'm not saying that let the tail wag the dog. I'm saying if pursuant to, my lords, the provisions of Article 233, my submission is that Article 233 clearly provides for two sources of recruitment. Article 233 does not provide for the manner in which those two sources will be operated. So the methodology or the proportion in which those two sources are to be operated, etc., are matters for the executive in consultation with the High Court to decide by statutory rules. My argument is not that the statutory rules will interpret the Constitution at all. Let me just clarify. If the statutory rules have been framed under 309 and they pertain only to the manner in which the two sources are to be operated on the ground,
There is no dispute on that. You don't dispute that.
Then
their argument is also the same.
no, my lords. They are saying please set aside all the rules. Mr. Shankaranarayan said that as a corollary to your interpretation of the Constitution, you should set aside the rule.
If you hold
Yes.
that the view taken by so many number of benches, that there is a reservation for advocates provided under 233, is not correct. If we hold that the law laid down is not correct, and if the rules do provide for that on the basis of the interpretation, would the rule survive?
No, my lords, my argument is slightly different, lords. If your lordships hold that the reservation that the court has said that Article 233 reserves 25%, then of course, and your lordships find that Article 233 does not reserve, then of course that reservation would be wrong. But if your lordships find, as I'm saying, that Article 233 provides for two sources of recruitment without providing for any particular manner of implementation, and rules are then framed in accordance with 233, not in conflict with 233, which provide...
Therefore, we'll have to interpret what
yes.
233.
So
then go to a question as...
So I'll just come to it. I'm just formulating the point, and I'll just make good the point. Point is only this, that if once the rules are there and the rules are statutory rules, unless your lordships find that the rules are ultra vires the Constitution and strike them down, that's the point, lords. That's the point.
Sure.
I would submit.
When the mother source does not even facilitate this, it is like there's no existence thereafter. That's what it is. We don't think that you have
let me
position to argue on that. Every enactment or a rule has to be traced to the Constitution.
That's right.
That's right. So therefore, when we say that this is what the Constitution is, as we understand, as we interpret, the consequence would follow.
No, I'm sorry. Every rule,
whether we declare it or not,
my lord,
by virtue of the order, let us assume that we hold.
Yes.
And now 233 as a whole prescribe both the categories, and with specific reference to 233(2).
My lord.
It only speaks about eligibility of the advocate and pleader.
That's right.
Then a consequence would follow. We did not even say anything.
No, I'm sorry. I didn't make myself clear, Milord, and I'll come to it, Milord. Let me proceed with it. What I'm saying is only this, Milord. If the Constitution provides for two sources, does not give the apportionment between the two sources, does not bar apportionment of X or Y percentage to one source or the other, your lordships have held in several judgments that you don't need a constitutional power except for the lists. You don't need a constitutional power to apportion those, because that apportionment is an executive act by the employer.
Maybe right. What
Yes.
Maybe right.
Yes.
We'll tell you why.
Yeah.
For example, let us take it in this case, 75-25.
My lord.
Now, let us say that 25, they are also entitled to participate, lawyers also and advocates are entitled to participate. In that, a rule is framed saying that specific reservation. Maybe you have a point, but to make them ineligible even to get you into this, there, unless the Constitution otherwise so declares, we can't do this.
No,
That will be they're going to the very root of the case now.
The Constitution, unless the Constitution bars it, the apportionment of quotas, your lordships have consistently held. Now, for instance, direct recruitment and promotion. Nowhere in the Constitution does it say that direct recruit should have 33% or 22% or 10%. That is for the executive to decide. But let me get on, because I'll have to take your lordship through the specific judgments which so hold. But the point here is, and I was just giving your lordship the broad perspective in which I'm placing it. Now, let me straight away come to Chandra Mohan, Lord. So, and show your lordship that the subsequent judgment.
You understand, appreciate that. Any reservation will create a classification. When then their classification will have nexus to the object where the intelligible there.
The reservation.
So now we are just going into a separate issue now. We are on the power as conferred under section.
The power is not exercised. The power is not exercised under 233 per se, because even 75%. Where does 75% come from? 75% is only for those serving on promotion.
What we are saying, see,
so
in that 75%, their argument is very simple.
Yes.
You have to see 233 as a whole.
Yes.
But it said 233 it says about the different modes: appointment, direct appointment, promotion, and posting.
Yes.
This applies to both categories.
My lord.
Yeah, but 233 merely says about the eligibility. Now what you are saying, still it is the power to have reservation or even reserve particular post is well within the domain of the executive. Now, in so far as the post will otherwise filled up a promotion, obviously you are out of the reckoning, because you will not be considering that category. That leaves the other part. The question is whether any bar is there. Under the Constitution is not there.
That's right.
Now, you are saying that
I'm saying that rules have been framed.
You can do it.
I'm saying rules have been framed under 309. The rules, in most of the cases, the rules are not under challenge. In one case where the rules were challenged, the Allahabad High Court rejected the challenge. Now I'm only saying.
As we understood the rule also, what it is not proceeding as you are saying. Rule proceeds as if this 25% is only meant for the advocates. Therefore, we will not. Suppose the rule.
No, I'll take your lordship.
Says, let us say there are 10 posts vacant by computation of 25%. In the 10 posts, 3 are reserved for lawyers, advocates, and pleaders. 7 are in the open category. Even then, it may be a contention for you to argue.
I will show you, lordship.
With respect to the object and etc. and all other factors. Intelligent difference.
So the rules, several of the states' rules provide that the quota which is reserved for, that is the direct recruitment quota, if the sufficient advocates are not found, then those posts automatically get added to the promotion quota.
All India Judges Association first case.
I'm sorry, Milord?
That is again because of the judgment of this court in the All India Judges first case.
Milord, there were rules even earlier. Now, even the Shetty Commission had noticed that there was in certain states there were rules which provided for certain quotas, etc. All India judges, what it did was it sought to have a uniform status around the country. The point is not that. The point is, Lords, the Haryana rules, for instance, the Kerala rules, there are certain rules which provide that if the sufficient advocates are not there to fill the quota, those vacancies automatically get added to the promotion quota. So they are there. Now, in the manner in which it is being implemented, there will be no advocates. For instance, in this Rajneesh case, out of 8 vacancies, 7 are filled from munsifs. So 7 vacancies for direct recruitment are filled by munsifs.
We suppose you are quite well aware of Article 13. We need not say anything. I think these are all too fundamental for us to even hear the arguments on these things. Once we declare what the Constitution says, the consequence would flow. No law will
declaration of what the Constitution says was always there. That has not varied.
So that declaration. Why are you asking us to interpret the Constitution on the basis of the rules?
I'm not doing that. So let me come back.
According to you, 233 has been correctly interpreted by the various 3 judges benches. Shows that.
That's right. That's right. So let's kindly come first of all to Chandramohan, Lords. If your Lordships are kindly see the second Constitution bench judgment in Chandramohan, that is, Lords, in volume 5.1. As I said, my learned friend Mr. Nilesh Gupta will take your Lordships in more detail into these. I am only pointing out the 2 sources of recruitment from this. So page 180 of volume 5.1. Here the PDF and that match. The PDF and the physical paging are exactly matched. 180 PDF also. Oh, I'm sorry. Now, your Lordship will see, my Lords have page 180, Lords? Yes. 180 of volume 5.1. Yes, we have the judgment, yes. So, your Lordship may kindly come to page 186. I won't trouble your Lordship to read the rules, but your Lordship will see the bench noted at the foot of the page that in this context, rules whereunder selections are made are relevant, and they set out Rule 8, which was that the governor shall decide the number of recruits to be taken at each selection from each of the 2 sources of recruitment specified in Rule 5. Rules 9 to 12 prescribe the qualifications, etc. Then kindly come straight away to page 192, where after examining 191, I'm sorry, 191. Lordship, just see the top of 191 with this background. My Lord, have that?
191.
191. The second para at the top with this background.
Yes.
With this background, if the following provisions of the Constitution are looked at, the meaning of the debated expressions therein would be made clear. We have already extracted 233. Then that part there, all the articles 234, 235, 236, 237 are set out. Now come overleaf, the gist of the aforesaid provisions. So the entire provisions of that part, that is part 6, chapter 6 of part 6 of the Constitution. The gist of the said provision may be stated thus: appointments of persons to be and the posting and promotions of district judges in any state shall be made by the governor of the state. There are 2 sources of recruitment, namely 1, service of the union or of the state, and 2, members of the bar. The said judges from the first source are appointed in consultation with the High Court, and those from the second source are appointed on the recommendations of the High Court. But in the case of appointments to persons to the judicial service other than as district judges, now these are the lower posts, they will be made by the governor of the state and according to the rules framed by him in consultation with the High Court and Public Service Commission. But the High Court has control over all the district courts and courts subordinate thereto. The main part I'm reading is the gist of the provision is appointment shall be made and posting by the governor on the consultation of the, and there are 2 sources of recruitment, service and members of the bar. Please note that the Constitution bench did not say on qualification. They said the 2 sources are those in service and those who are members of the bar. Because I'll show you, Lordship, pursuant to that, rules are framed several rules like Kerala rules, which I'm concerned with, categorically say it's only members of the bar who are eligible for direct recruitment.
Dispute because there are two sources, because.
That's right.
Let us say 10 vacancies are there. The 10 vacancies will be filled up by the service candidate and the members of the bar. That's what they are saying.
That's right.
They don't think about the quota and other things. They only say out of 230.
So the source is members of the bar. Now kindly come to Satya Narayan.
As well as the chief has pointed out.
Now
in Chandramohan, applications have been called for and applied, and then which is applied and responded to by the judicial officer also. And nobody has objected to it. The objection was with respect to the so-called eligibility criteria. Not on the count of 7 years and other things. And not that they are debarred and their application by say is not maintainable.
No, that is under rules. I'm coming to that. That is under rules. The apportionment of the two sources is under rules. And that I'll show your lordship that the executive has every power to do that.
Those rules also, which are consideration which fell for consideration in Chandramohan, the barristers, lawyers, so also the judicial officers could apply.
Could apply there, but thereafter.
So the question was whether the judicial officers could be the executive.
Thereafter, so the sources. No, the point I'm making is that there are two sources. The fact that one of those sources could be filled at that time from both. I'm not disputing that.
I can tell you this. Let us assume they are in the part of the judicial service as envisaged by this court in Chandramohan. Then the problem would not have arisen, because nobody has questioned the rule, nobody has challenged it so far as the eligibility of a judicial officer coming under the judicial service to participate. That is why you see page 187, which we have the rule recorded.
I'm saying, my lords, that it is so far as the apportionment, the Constitution only provides for two sources. And from that is by promotion and from the bar. That is what the Constitution provides. Now, how should the apportionment take place? At that time, those particular rules which were in consideration did allow, even for the direct recruitment, they did allow certain subordinate judicial officers also to vie for that at that time. Subsequently, rules are changed and the rules provide.
Therefore, you are again going to the same thing. When we are on the interpretation of 233.
I'm not.
Why are you again harping on the rules?
So 233, I'm saying 233 is very clear.
So you show us a bar from 233.
233.
Wherein for direct recruitment from the category of lawyers, advocates having 7 years practice. Yes. The members who are already serving in the judiciary are prohibited.
Because they are not advocates, they are not members of the bar. You cannot be an advocate.
What you have read, next paragraph, 2 lines, that will make you clear.
I'm sorry,
the paragraph you have read.
Yes, sir.
Come to the next paragraph, first two lines.
Yes. So far there is no dispute.
Then please read the next line.
But the real conflict rests on the question whether the governor can appoint as district judges persons from services other than judicial service. So this was the issue there was.
Please read.
Quite so, I'm only pointing out the issue.
Please read next line.
Yes. That is to say, can you appoint a person who is in the police, excise, revenue of such other services?
So this was the issue.
Yes.
Now,
so that is applicable for promotion also.
Somebody who is a revenue department, someone else, they cannot be part of this.
They
can't even make an application.
That applies to promotion. That doesn't apply to direct recruitment.
If there is a promotion, there is no question of challenge then.
No.
That's the question of challenge to you.
No, the promotions were being made from services other than judicial service.
No.
Yes, because those services had people who were doing legal work.
This is meant for, this is not a promotion, direct recruit. This is what we are saying. There is not much of an argument that is actually required. See, for the first judgment and then followed by Chandramohan, everybody proceeded on the footing that a judicial officer coming from the judicial service is entitled to appear and then par with the advocate.
Because the rules so provided.
Yes.
Because the rules so provided in that case. So the only question.
Therefore, we are telling you, Chandramohan is not as you are contending. There is not. There is no
I'm
choice
sorry.
there.
My learned friend, Mr. Gupta, will deal with that. I'm only pointing out that as far as Chandramohan is concerned, it clearly recognizes that there are two sources of recruitment in 233, nothing more. As far as 233 is concerned, it does not deal with the apportionment between the sources. That's what I'm saying. That is a matter for the executive in consultation with the High Court to frame statutory rules for. I'm not saying that the rules will dictate the constitution. So now come to Satyanarayan, which is at page 395.
So you are relying Chandramohan only to the extent that Chandramohan recognizes two sources.
Only two sources. That 233 has two sources, nothing more, nothing less. Chandramohan, I'm saying there is no bar. There, 233 does not bar 100% from one source or 50% from one source or 10% from one source. That is a matter for the high courts to decide, because the high courts know what is best and they have to, in consultation with the governor, frame rules. In any service, direct recruitment, promotion, etc., how it should be apportioned, what should be reserved for whom is not, I'm not talking about constitutional reservations for SC/ST. I'm not talking about those specific reservations which are there in the constitution for particular classes of persons, or for women's reservations, or for reservations in political posts and so on. I'm talking about apportionment of posts within a service between direct recruits and promotees, between so and so and so and so from different sources. That is a purely executive decision. In this case, the executive, being the High Court, in consultation with the High Courts, frame the rules and the governor promulgates them. At that time, the rule which was there allowed somebody else also to be vying for it. Over a period of time, it is found that if there are 4 apples available, 3 apples are going to the judicial officers, 1 apple should be given to direct recruits, confined to those who are members of the bar. And that is how the rules, several rules have been framed.
On the basis, this is only on the basis of the judgments of the court. The High Courts have not framed the rules on their own. The High Courts have framed the rules on the basis of the judgment in All India Judicial Officers Association first case.
Given that once rules are framed on the direction of the Supreme Court or on a recommendation of the Supreme Court, whatever it may be, in this case it was a direction, once rules are framed under 309, it is only the rules that prevail, not the direction of the Supreme Court. Yes. And then the Supreme Court can test those rules as being either intra vires the Constitution or ultra vires the Constitution. But the source, the original the inspiration for those rules doesn't exist anymore. It is the 309 rules which have to be tested on their own standing. Are those rules violative of 233? Are those rules violative of 14? Are they violative of 16 of the Constitution of India? Are they beyond legislative competence? But those rules do not get wiped out because the original inspiration of the rules came from a direction or from a recommendation of the Honorable Supreme Court. They still have to be tested as statutory rules. That is my point, Lords. So now, Lords, kindly see Satyanarayan. Right or wrong, I'm saying Satyanarayan then as a 3-judge bench interpreted in 1985, we are talking about 40 years ago, comes up with an interpretation. That interpretation then stands the test of time. And the whole country is ordered on that basis. Appointments are made. Exercises are done. Recruitment exercises are done for a 40-year period on the basis in rules framed by various states. So let's please see Satyanarayan now.
Yes.
The same volume, volume V 5.1, 395. Page 395. Now, I'll just give a brief line of background. The Allahabad High Court had ruled against the judicial officers who had applied for these posts. The first batch came up. Honorable Justice Chinnappa Reddy's bench dismissed it summarily saying that we approve of the High Court judgment, and they didn't even give reasons. They were so clear about it. But then when another batch came up, they said, now we are compelled to give reasons. Why? Because this is happening again. So if I may just read at 397, line 4, my lords. Or let me just read, it's a few lines, let me just read it from the beginning, at 396. The petitioners in the several writ petitions before us, as well as appellants in civil appeals so-and-so, which we dismissed on 11th October 84, were members of the Uttar Pradesh Judicial Service in 1980, when all of them, in response to an advertisement by the High Court of Allahabad, applied to be appointed by direct recruitment to the Uttar Pradesh Higher Judicial Service. They claimed that each of them had completed 7 years of practice at the bar even before their appointment to the Uttar Pradesh Judicial Service, and were therefore eligible to be appointed by direct recruitment to the Higher Judicial Service. As there was a question about the eligibility of members of the Uttar Pradesh Judicial Service to appointment by direct recruitment to the Higher Judicial Service, some of them filed writ petitions in the Allahabad High Court. The said petitions were dismissed, and it was held that members of the Uttar Pradesh Judicial Service were not eligible to be appointed by direct recruitment to the Uttar Pradesh Higher Judicial Service. Civil Appeal 548 was filed in this court after obtaining special leave under 136. By virtue of the interim order passed by this court, members of the Uttar Pradesh Judicial Service who desired to appear at the examination and selection were allowed to so appear, but the result of the selection was made subject to the outcome of the civil appeal and the writ petitions in this court. The civil appeal and some of the writ petitions were dismissed by us on 11th October 84. Remaining writ petitions are now before us. Learned so-and-so and so-and-so learned senior counsel who appeared for the petitioners tried to persuade us to reopen the issue, which had been concluded by our decision on 11th October. Having heard them, we are not satisfied that there is any reason for reopening the issue. When we dismissed the civil appeal and the writ petition on the former occasion, we were content to merely affirm the judgment of the High Court of Allahabad without giving our own reasons. In view of the arguments advanced, we consider that it may be better for us to indicate briefly our reasons. The submissions of learned senior counsel was that there was no constitutional inhibition against members of any subordinate judicial service seeking to be appointed as district judges by direct recruitment, provided they had completed 7 years practice at the bar. The submission of learned counsel was that members of the subordinate judiciary who had put in 7 years practice at the bar before joining the subordinate judicial service and who had gained experience as judicial officers by joining the subordinate judicial service ought to be considered better fitted for appointment as district judges because of the additional experience gained by them, rather than be penalized for that reason. The learned counsel submitted that a construction of Article 233 of the Constitution, which would render a member of the subordinate judicial service ineligible for appointment to the higher judicial service because of the additional, perhaps it should be experience gained by him as a judicial officer, would be both unjust and paradoxical. It was also suggested that it would be extremely anomalous if a member of the UP Judicial Service who on the present construction of 233 is ineligible for appointment as a district judge by direct recruitment, is nevertheless eligible to be appointed as a judge of the High Court by reason of Article 2172 AA. That's what my learned friend Mr. Shankar Nayan relied on. On the other hand, learned counsel for the respondent urged that there was a clear demarcation in the Constitution between two sources of recruitment, namely those who were in the service of a state or union and those who were not in such service. He contended that the second clause of Article 233 was attracted only to the second source, and in respect of candidates from the source, further qualification of 7 years as an advocate or a pleader was made obligatory for eligibility. According to Mr. Subramaniam, I can just skip over this. At the foot of the page, they said both sides relied upon the decisions of this court in Rameshwar Dayal versus State of Punjab and Chandra Mohan versus State of UP. Then Article 233 is set out, and below that the extract, 2 points straight away project themselves when the two clauses of 233 are read. The first clause deals with appointments of persons to be and the posting and promotion of district judges in any state, while the second clause is confined in its application to persons not already in the service of the union or of the state. We may mention here that service of the union or of the state has been interpreted by this court to be in judicial service. This was in Chandra Mohan, only judicial service. Again, while the first clause makes consultation by the governor of the state with the High Court necessary, the second clause requires that the High Court must recommend a person for appointment as a district judge. It is only in respect of the persons covered by the second clause that there is a requirement that a person shall be eligible for appointment as district judge if he has been an advocate or a pleader for not less than 7 years. In other words, in the case of candidates who are not members of a judicial service, they must have been advocates or pleaders for not less than 7 years, and they have to be recommended by the High Court before they may be appointed as district judges. While in the case of candidates who are members of a judicial service, the 7 years rule has no application, but there has to be consultation with the High Court. A clear distinction is made between the two sources of recruitment, and the dichotomy is maintained. The two streams are separate until they come together by appointment. Obviously, the same ship cannot sail both the streams. That is not slip, it should be ship. Obviously, the same ship cannot sail both the streams simultaneously. The dichotomy is clearly brought out by S.K. Dasje and Rameshwar Dayal versus Punjab, where he observes Article 233 is a self-contained provision regarding the appointment of district judges. As to a person who is already in the service of the union or of the state, no special qualifications are laid down. And under clause 1, the governor can appoint such a person as a district judge in consultation with the relevant high court. As to a person not already in service, a qualification is laid down in clause 2, and all that is required is that he should be an advocate or pleader of 7 years standing. Again, dealing with the cases of Harbans Singh and Soni, it was observed, we consider that even if we proceed on the footing that both those persons were recruited from the bar and their appointment has to be tested by the requirement of clause 2, we must hold that they fulfill those requirements. Clearly, the court was expressing the view that it was in the case of recruitment from the bar, distinguished from judicial service, that the requirements of clause 2 had to be fulfilled. We may also add here, earlier, the court has also expressed the view, we do not think that clause 2 of Article 233 can be interpreted in the light of the explanation added in Articles 124 and 217. In those explanations, there's a clubbing of periods of judicial service and that. So they said, we may add here that the court had also expressed the view, we do not think that clause 2 of Article 233 can be interpreted in the light of the explanation added to 124 and 217. In Chandramohan versus Union, Uttar Pradesh, Honorable Justice Subba Rao J said so and so, and I've already read that, so I won't trouble your lordships. But after setting out that portion, their lordships say at page 401, just below the, he proceeded to state, but the sources of recruitment are indicated in clause 2 thereof. Under clause 2 of Article 233, two sources are given, namely persons in the service of the union or the state and two advocate or pleader. These are the two distinct sources maintained by the Constitution bench and followed by the learned three-judge bench. Posing the question whether the expression the service of the union or of the state meant any service of the union or of the state, or whether it meant the judicial service of the union or of the state, the learned Chief Justice emphatically held that the expression the service in Article 233(2) could only mean the judicial service, but he did not mean by the above statement that persons who are already in the service on the recommendation by the High Court can be appointed as district judges, overlooking the claims of all other seniors in the subordinate judiciary, contrary to Article 14 and 16 of the Constitution. Thus, we see that the two decisions do not support the contentions advanced on behalf of the petitioners.
What are the reasoning given as to why they do not support?
I'm sorry, Minister?
What is the reasoning given?
The reasoning is set out above, that there are two separate streams and the two ships cannot sail together. They merge into one card only after appointment. It is only after appointment.
Where does Ramdayal and Chandramohan state so?
So I'll leave that to my learned friend, Mr. Gupta, because I don't want to, because my time is limited. I'm only saying this is a view taken by the three judges bench. It may be right, it may be wrong. I'm saying this has held the field for 40 years.
So,
Dheeraj More.
So the 5 judges would be bound by 3 judges.
No, I'm saying the Dheeraj More did not carve out anything new. Dheeraj More has merely reiterated this. And Dheeraj More has merely reiterated what was said after this in Sushma Suri, what was said in Lord Agarwal, etc. Deepak Agarwal and all. Several three-judge benches and so on. So it is not as though Dheeraj More came up with something new. There was no new formulation there. I'm not for a moment saying, if your lordship find that this is something absolutely anathema to 233, it's one thing to say that your lordship may have a slightly different viewpoint. There may be a possible alternate viewpoint. But if your lordships don't find that this is anathema to 233, that this leads to a complete sort of distortion of the constitutional intention, then what has held the field for 40 years and what is reiterated time and time again for 40 years, that should not, in my respectful submission, be upset by the Honorable Court. Now, let's come straight away. This is then followed in Sushma Suri, which your Lordship will find at volume 5.2 at page 530. This was a judgment of 1998 or 1999. Volume 5.2. Page 530 in volume 5.2, your Lordship will find the judgment of another learned 3 judges bench in Sushma Suri. Now, here what had happened was that persons who were working as lawyers, but in government posts like public prosecutor, etc., they had applied for district judge. So what had happened in Oma Shankar's case, that had been rejected by the High Court. If your Lordship are kind enough just to see at page 533, the second para, the High Court in Oma Shankar's case. The High Court had, in this case, in the case of Mrs. Sushma Suri, the High Court followed its own judgment in Oma Shankar because Supreme Court had dismissed the SLP there, holding that the public prosecutors are not eligible as members of the bar. So now, after setting out that, their Lordships, if your Lordships kindly just take the second para, may I just read that, that 533? The High Court in Oma Shankar's case held that there are 2 sources of recruitment to Delhi Higher Judicial Service, namely officers in Delhi Judicial Service and advocate or pleader of not less than 7 years standing. The petitioner therein being in the service of union administration could not fall under first category, nor could he be treated as an advocate, since the law officers of the government, such as public prosecutors and government counsel, may not cease to be advocates for purpose of Advocate Act, but yet they are not members of the bar. That was held in that case. On that basis, the claim was denied. In the special leave petition, this court held that the appellant, being a public prosecutor, was in service of union territory and as such was not eligible to be considered for appointment in Delhi Higher Judicial Service. However, whether such public prosecutor would be an advocate was not considered by this court. The stand of the parties in these cases is identical as in Oma Shankar's case. Hence, we wish to examine the correctness of the view expressed as to whether a public prosecutor, standing counsel, would cease to be an advocate for purpose of 233(2). Now see the next para. The rules of recruitment have been framed under proviso to Article 309 of the Constitution, known as Delhi Higher Judicial Service Rules 1970. Rule 5 thereof provides for the mode of recruitment. The recruitment of persons to the service shall be made by the administrator in consultation with the High Court. In regard to the persons not already in Delhi Judicial Service, appointment to service shall be made by the administrator on the recommendations to be made by the High Court. Rule 7 pertains to regular recruitment and provides that persons who have been recruited and promoted on the basis of selection for members of the Delhi Judicial Service who have completed not less than 10 years of service in Delhi Judicial Service and by direct recruitment from the bar, provided that not more than 1/3 of the posts in the service shall be held by direct recruits. Obviously, this rule has been framed to be in conformity with Article 233 of the Constitution. Article 233(1) thereof provides for appointment of persons who are already in service, while 233(2) provides that a person not already in service while 2 provides that a person not already in service is eligible for appointment if he has been for not less than 7 years an advocate or a pleader and is recommended for the purpose by the High Court. referring to the expression service in 233(2), it has been held by this court in Chandra Mohan and in Satyanarayan Singh that it means judicial service. However, it is not the contention either before the High Court or before us that the appellant is in judicial service. On the other hand, the contention is that she has more than 7 years experience as advocate and is therefore fully eligible to be appointed to the higher judicial service, and High Court was not justified in not considering. So on this interpretation, they then decided that Mrs. Sushma Suri, because she was working as a lawyer, though a public prosecutor, she was eligible, but in her case, they couldn't give her the relief because in the meantime, the post had already been filled and so on. But this, what I'm saying is this became the conventional wisdom. This became the settled law. So again, now kindly come to all India judges. The next judgment blocks, which your lordships have in the SCC in volume 7. Where is that? Where is all India judges? Well, in volume 7, because they are also referring to the SCC judgment, various recommendations of the Shetty Commission were considered by your lordships. My lords, may just note, this is at page 43, sorry. Lords, it's printed page 4294, PDF 186 of volume 7, printed page 4294. And we are concerned with page. No, it's page. The one you just showed me. Just now you showed me. One second. Para 25, just the first two lines, because the court was fully cognizant of 25 at page 4315 running page and 207 PDF. Court was fully conscious of the fact that there were shortage of judges and so on. Para 25, an independent and efficient judicial system is one of the basic structures of our constitution. If sufficient number of judges are not appointed, justice would not be available to the people, thereby undermining the basic structure. Then let's come to para 27. And this is the difference between the constitutional requirement of two sources and what should be the method of operating those two sources. Para 27, this is at 4316, PDF 208. Another question.
Yes.
Another question which falls for consideration is the method of recruitment to the posts in the cadre of higher judicial service, that is district judges and additional district judges. At the present moment, there are two sources. I'm sorry.
Yes, yes, please.
Para 27, I was reading. About the third line, at the present moment, there are two sources for recruitment to the higher judicial service, namely by promotion from amongst the members of the subordinate judicial service and by direct recruitment. The subordinate judiciary is the foundation of the edifice of the judicial system. It is therefore imperative, like any other foundation, that it should become as strong as possible. The weight on the judicial system essentially rests on the subordinate judiciary. While we have accepted the recommendation of the Shetty Commission, which will result in the increase in the pay scale of the subordinate judiciary, it is at the same time necessary that the judicial officers, hardworking as they are, become more efficient. It is imperative that they keep abreast of knowledge of law and the latest pronouncement, and it is for this reason that the Shetty Commission has recommended the establishment of a judicial academy, which is very necessary. At the same time, we are of the opinion that there has to be certain minimum standards objectively adjudged for officers who are to enter the higher judicial service as additional district judges and district judges. While we agree with the Shetty Commission that the recruitment to the higher judicial service, that is the district judge cadre, from amongst the advocates should be 25%, and the process of recruitment is to be by a competitive examination, both written and viva voce, we are of the opinion that there should be an objective method of testing the suitability of subordinate judicial officers for promotion to the higher judicial service. Furthermore, there should also be an incentive amongst the relatively junior and other officers to improve and to compete with each other so as to excel and get quicker promotion. In this way, we expect that the caliber of the members of the higher judicial service will further improve. In order to achieve this, while the ratio of 75% appointment by promotion and 25% by direct recruitment to the higher judicial service is maintained, we are, however, of the opinion that there should be two methods as far as appointment by promotion is concerned. 50% of the total posts in the higher judicial service must be filled by promotion on the basis of principle of merit cum seniority. For this purpose, the High Court should devise and evolve a test in order to ascertain and examine the legal knowledge of those candidates and to assess their continued efficiency and with adequate knowledge of case law. The remaining 20. I was reading that in order to achieve this, while the ratio of 75% by promotion, 25% by direct recruitment is maintained, we are, however, of the opinion, this is placitum beam, we are, however, of the opinion that there should be two methods of appointment by promotion. 50% of total posts must be filled by promotion on the basis of principle of merit cum seniority. For this purpose, the High Court should devise and evolve a test in order to... I'm sorry. May I continue? For this purpose, the High Court should devise and evolve a test in order to ascertain and examine the legal knowledge of those candidates and to assess their continued efficiency with adequate knowledge of case law. The remaining 25% of the posts in the service shall be filled by promotion strictly on the basis of merit through the limited departmental competitive examination for which the qualifying service as a civil judge senior division should be not less than 5 years. The High Court will have to frame a rule in this regard. As a result of the aforesaid, to recapitulate, we direct that recruitment to the cadre of district judges will be 50% by promotion from among civil judge senior division on the basis of principle of merit cum seniority and passing suitability.
Directly.
25.
28C.
28C.
You want to show us that only?
Yes, please. That, so, Your Lordship, following the earlier judgments, Your Lordships have I was saying that this has become sort of, over a period of time, it became sort of graven in stone or carved in stone. Maybe the original roots which are, may have been on some shaky foundation, but the edifice which has been built is a solid edifice and which has stood the test of time. Now, Your Lordships are being invited by the petitioners to say that, look, there was some weakness in an original foundation.
Whether it has withstood the test of the time.
Yes.
All five of us have some experience.
Lords, the fact that, Lords, members of the bar that a service which consists of both members from the lower judiciary and members of the bar is a richer service. It has a much richer experience and a richer capacity to deliver justice is beyond cavil. Look at the high courts. Lords, your lordships are aware that we have learned judges coming from the district judiciary. We have learned judges who are directly elevated. That combination of directly elevated judges, nobody can say that a directly elevated judge who's come from the bar has less knowledge or experience or is bringing less to the table than the person who has worked for 14 or 15 years as a judge, as a district judge. Is it not proved by experience, my lords, that what is brought to the table by members of the bar is equal, at least equal?
This is, General said something yesterday, I don't want to say it openly. For me to say, you want to say? It will be again viral and
look, we know on this side, look, that the members of the bar who are elevated in the high courts as judges, which in fact might be perhaps in a court like the Bombay High Court, might be 2/3 or so might be from the bar, 1/3 may be elevated from the district judiciary. I'm not sure of the exact mix, but we know that they enrich the institution completely. They give strength and vitality to the institution. So
saying on that, that is exactly what we are trying to tell you.
No,
So long to have a better judiciary would enrich the institution much better. After all, you are facilitating members of the board into going to the judiciary. You create a better system, a better talent.
So we are only talking about 25% of the total.
See, more persons would come. It will enrich this institution. Obviously, it's going to be picked on merit only.
That's right.
It's only in the entry, so that it's all fair. Then the criteria will be the same, the objectivity is the same, the assessment will be the same. No problem at all.
So I'm only saying that we are talking about 25% out of 100 posts, 25 posts. And the several state rules provide that if sufficient candidates are not found, I'll show them to your lordship, they are on record before my lord, that if sufficient candidates are not available, automatically those posts also go to the promotion quota. So it's not as though several of them, Haryana provides that, I'll show your lordship.
All the states.
Not all states. I'm saying several states provided, some may not, but that may be something which is the High Court concerned may need to correct it, or that High Court may feel that in its wisdom, because the High Court is expected to know best about the local conditions of the state and what is required and all, they may perhaps believe that is the best available. But I'm only saying that it's not a case that it's not something where this 25% is a drag on the system. This 25%, I'm saying we must presume that they're going to enrich the system. Just because the judicial officer has judicial experience, they are getting 75% of the post for that judicial experience. 50% by way of long experience coupled with merit, and 25% by way of a certain limited amount of experience, but on a limited competitive examination, inter se only among themselves. By competing among themselves, they get 25% of those posts. So we are only, so these, now this then gets followed.
Where do you find the quota of 25% for the members of the bar?
In the rules.
In 233.
I'm sorry? 233 does not provide any quota. I'm very clear about that. I'm saying 233 provides only sources of recruitment. The method of recruitment is left to the high courts to evolve by framing of rules and the governor to promulgate those rules in consultation with the high courts. 233, if even in respect to say direct recruitment to any service or promotion to any service, those quotas are not provided in the constitution. Those quotas are provided by recruitment rules framed under 309. In every single service, the quotas are provided under rules under 309. It's not that you have to find them in the constitution. So then this is followed in Deepak Agarwal in 2013, another 3-judge bench. So your lordship may just make a note of that because my time is running out. I don't want to, your lordship will find that Deepak Agarwal is in the same volume 7 at page 4322, running page 4322, PDF 214. Deepak Agarwal is 2013, again a learned 3-judges bench. At running page 4322, PDF 214. Paras 89 to 92 may just be noted by your lordships. Paras 89 to 92. Because I want to just place this. So we have now 1985, 1999, 2002, 2013. 4 3-judges benches saying exactly the same thing. And then one or two benches of two learned judges felt that they could carve out a new avenue to let's bring in judicial officers into the quota reserved in the rules. In the rules, I'm making it clear, reserved in the rules for members of the bar. And that led to Dheeraj more, not to carve out new law, not to lay down new law, not to reinterpret the constitution, but to just reassert what was said in 1985, 1999, 2002, 2013, and several other times. I'm only giving the 4 3-judge benches. There are others also which have said so, including some 3-judge benches.
Yeah.
So in this background, Lords, I have set out in my written submission No, I'm sorry, if I can just read my colleague rightly says, if in Deepak Agarwal, if I could just read 1 or 2 paras at page 4322 of volume 7, at page 2, 4371, 4371, para 89. May I just read that, Mlod?
Para 89.
Para 89. At running page 4371, PDF 263. We do not think there is any doubt about the meaning of the expression advocate or pleader.
1 minute.
We do not think there is any doubt about the meaning of the expression advocate or pleader in Article 233(2) of the Constitution. This should bear the meaning it had in law preceding the Constitution and as the expression was generally understood. The expression advocate or pleader refers to legal practitioner, and thus it means a person who has the right to act and or plead in court on behalf of his client. There is no indication in the context to the contrary. It refers to the members of the bar practicing law. In other words, the expression advocate or pleader in Article 233(2) has been used for a member of the bar who conducts cases in court, or in other words, acts and or pleads in court on behalf of his client. In Sushma Suri, a 3-judge bench of this court construed the expression members of the bar to mean class of persons who were actually practicing in courts of law as pleaders or advocates. A public prosecutor or a government counsel on the rolls of the State Bar Council and entitled to practice under the 1961 Act was held to be covered by the expression advocate under 233(2). We respectfully agree. In UP State Law Officers Association, this court stated that though the lawyers of the government or a public body on the full-time roles of government and public bodies are described as their law officers, but nevertheless they are professional practitioners. It is for this reason the court said that the Bar Council of India in Rule 49 of the BCI rules in its original form in the saving clause waived the prohibition imposed by the said rule against the acceptance by a lawyer of a full-time employment. Look, judges, even subordinate judges, when they become judges, they cease to be advocates. They are not on the rolls anymore. Their sanad is suspended. So they can't be considered members of the bar as long as they are judges. Then in Sushma Suri, a 3-judge bench of this court, and then Sushma Suri is set out in para 92. Their lordship will summarize that. And then where there was some slightly differing opinion, the lordships of the 3-judges bench reiterated the legal position.
Before the court was as to whether the public prosecutors, government advocates are entitled to be treated as advocates or not.
In Sushma Suri.
APPs also cancel their sanad. They are in the regular roles of the state government.
Sushma Suri dealt with public prosecutors who are appearing in court.
What are public prosecutors? APPs in Kerala, it is called assistant public prosecutors. They do the criminal prosecution in the magistrates' court and all that. They are in the regular employment of the government. They cancel their sanad.
But
Correct, Mr. Pudot.
perhaps that may be so as the Bar Council said.
Cancellation of sanat is not a very big issue.
I bow to the court.
Especially looking at UP state law officers association.
I can't take exception to that because I'm not familiar with the Bar Council rules in Kerala. My submission is that the Supreme Court has said that those who are actually practicing law in courts, whether they are on the rolls of a government or not.
They cancel their sanat, they appear in courts as prosecutors, but they don't wear the band, they wear a tie and a coat.
I see.
So they, assistant public prosecutors in regular employment cancel their sanats.
Someday your lordship may need to consider whether they are eligible or not.
They are already eligible as well.
Yes, so as per Sushma Suri, as per the judgment in Sushma Suri, they are clearly eligible if they are actively and on a regular basis practicing
They are regularly practicing in a court, but only in magistrate's court.
No, then in paras 85 and 86 of this judgment, I think that is also dealt with. But if your lordship kindly sees para 85 at page 4368, that may answer that point. So, that para 85, after setting out Johri Mal, then overleaf at 4369, just after that extract of Johri Mal, it says, as regards public prosecutor, this court has consistently held, Placidum A, my lords, on 4369. As regards public prosecutor, this court has consistently held that though public prosecutor is a holder of public office and he holds a post, yet he is not in government service as the term is usually understood. Despite these differences, for the purposes of 233(2), there is not much difference in a public prosecutor and an assistant public prosecutor, and both of them are covered by the expression advocate. It is so for more than one reason. And then their lordship set out those reasons. But we are not really concerned with that. I'm only saying that so far as these two streams are concerned and that there could be a reservation for the members of the bar, that has the view taken by your lordships, 1985 onwards, right through till 2013, several three-judge benches. That's I was only trying to place that point. On that, lords, in my note, in my written submission, which is the first one in volume 2, the first one in volume 2, I've set out the very first section at page 5 deals with the principle of stare decisis, and 3 constitution bench judgments which dealt with that. Volume 2 in my note. Sorry.
Volume 2.
No, but the rule is, let's not get into it.
Page 5.
Volume 2, page number 5.
In Deepak Agarwal, there is
volume 2 is a written submissions of the respondent, so to speak.
In Deepak Agarwal, my lord, there is one paragraph which is important, which is paragraph 51.
Deal with it in your own turn.
Very well. Where they hold, my lord.
You have already shown that para.
No, Deepak Agarwal I didn't touch at all. Para 51 is the relevant para where they presume that 233(2) excludes the appointment from the judicial service. That which is incorrect, not borne out from either of the two constitutions.
Para
51, my lord. Last 5 lines or so of that. Even though this was not the issue in that case. The only issue was whether public prosecutor. But somehow they've come to this conclusion without saying how.
But none of the judgments considered Rameshwar Dayal, wherein the appointment of Swani and Harbal Singh, though at the time of their appointment were in service, has been found to be valid under 230B.
I'm sorry that at
None
that time,
of these subsequent judgments consider the position that in Rameshwar Dayal, the Constitution bench has found that the appointment of Harbal Singh and P.R. Swani, who at the relevant time were holding some post, was also valid under Article 233.
Sadar was also suspended.
So,
Recorded.
they are not on the role of both of them were not on the role of the bar association on the date of their appointment.
well, my learned friend Mr. Gupta would answer that. I just want to, if I can move on and just conclude these aspects. So what I've set out.
Your main argument is for last 60 years, an erroneous position has been held.
Quite so.
Not this court should not change the same.
Yes, not erroneous.
The erroneous is or supplementary.
An interpretation which is in keeping with Article 233, according to me. Article 233 provides for two sources. Now we come to the rules. So now I'm coming to the next point.
The rules, how can we
I'm not. I'm on the statutory rules. Unless your lordships find that those rules are ultra vires in the Constitution and strike them down. That is the point. So lords, I have set out notes at from page 5 onward. The doctrine of stare decisis, and your lordship may just come to Sharp Hazel judgment, which your lordship will find is in volume 5.3.
We are not going to unsettle the position which has been holding the field till now. We are not going to set aside the appointments of the persons who are already in appointment or so. Whatever we'll be holding it prospectively from the date of our judgment.
I'm on that. I'm saying that this position with regard to these rules. Now, so your lordship may only make a note that from page 7 to which page of my written submissions, I've set out the principle of stare decisis with extracts from 3 judgments, including Sharp Hazel which is a 3 paras 17 to 19 of Sharp Hazel, and Sharp Hazel judgment is also in volume 3 at page 1034. Volume 5.3.
Which judgment?
Sharp Hazel, that was a judgment of a constitution bench. My lord, the Honorable Chief Justice was also a member of that bench, where the issue was whether those 2 judgments, Sampath Kumar and in court number 3, whether Sampath Kumar should be referred to a larger bench, two judgments of in the context of Article 370. Yes. So if your lordships come to page 1047.
You already quoted the paragraph.
Para 17 to 19 of this.
You already quoted in your.
Lots are noted that. So that may just be.
Last week also I have relied on stare decisis in that judgment from Haryana.
Yeah. Now, my lords.
There the situations were different. Over the last 20 years, on the basis of a law laid down in Gurjan Singh, the transaction had taken place, the partitions had taken place, and therefore, in that context, here, even if we hold either way, we are not going to touch the appointments or the whatever finality has.
No, quite so. I'm submitting that your lordships ought not to vary this interpretation of the Article 233 in consonance with the rules, which has held the field.
Even if it is on an incorrect interpretation of the 2 constitution benches.
No. If your lordships find that that the interpretation placed in Satyanarayan independently of the constitution benches, I'm submitting that interpretation is a perfectly valid interpretation, even independently of the constitution benches, which which will be made good. But come for a moment.
The law, as we understand, is that the judgment of 5 judges is binding on 3 judges, and 3 judges binding on.
But the five judges have not said anything contrary. So now let me just make good my second point. The point is that Article 233 only prescribes 2 sources of recruitment. This point is very important. My lord, may kindly make a note of it. Article 233 provides for 2 sources of recruitment, but does not provide for the method of recruitment or the manner of apportionment between the 2 sources. That is left for the High Court's concerned in consultation with the governor in consultation with the High Court to make rules for. Now, in that context,
yes.
So the point is, I'm not now saying that 233 should be interpreted in the context of the rule. I'm saying 233 requires that rules be framed for the apportionment and for the method of recruitment. 233 has nothing in it about the method by which those 2 sources will be operated. Nothing, zero. Now, please see, my lords, your lordships have over a long period of time taken the view that so far as the method of recruitment and apportionment of posts between different categories are concerned, that is exclusively the purview and prerogative of the executive. In this case, the High Court, I would say. I would substitute the executive by the High Court. So please see, my lords, the Constitution bench in Bishan Sarup Gupta, Lord, that judgment is not in the compilation. 1975, volume 3 SCC, 116, I'd asked for the books to be called. 1975, 3 SCC 116. 1975, 3 SCC 116, Bishan Sarup Gupta was the Union of India. 116. 1975, 3 SCC 116. Now here the promotees contended that though the Supreme Court had asked for a rule to be framed, that rule was unfair to them. That contention, your lordship will find in para 16 at page 127. And then come to para 17. Para 16 just sets out that their contention was that though Supreme Court directed rule to be framed, that rule was unfair to the promotees because it didn't give them sufficient weightage, etc. Now, para 17, the Constitution bench said, when considering, may I read that was page 128? When considering this point, it must be clearly understood that this court is not concerned with the government's policy in recruiting officers to any service. Government runs the service and it is presumed that it knows what is best in the public interest. Government knows the caliber of the candidates available, and it is for the government to determine how a particular service is to be manned, whether by direct recruits or by promotees or by both. And if by both, what should be the ratio between the 2 sources having regard to the age factor, experience, and other exigencies of service. Commissions and committees appointed by the government may indeed give useful advice, but ultimately it is for the government to decide for itself. In the particular service with which we are concerned, class 1 income tax officers, government had known for many years, there was a lot of discontent, etc., etc., etc. I'm asking your lordships to read the High Court and the governor in place of the government here, governor in consultation with the High Court. Now, this is the principle which has been followed, and I'll give the citations, lords. These judgments are not on record because this issue of quota only fell from your lordships in response to argument made by the other side orally. That how can a quota be framed if it is not in the Constitution in Article 233. So I'll just note if I can tell your lordship that this has been followed, this principle is followed. Lord, in Dwarka Prasad, that is 2003, volume 6, SCC 535. Dwarka Prasad, 2003, volume 6, SCC 535.
1 minute. 2003,
volume 6, SCC 535. 6 SCC 535, my lord. We just handed up the book, my lord. And look, para 16 of this judgment said that where there are different feeder cadres, may I read that, my lord? It's a very short para. Para 16.
So we are not going into the rules. The rules here, they are framed only on the basis of the judgment of this court.
So, no, first of all, power. No, I'm on the source of power.
We are not disputing that the High Court has the power to frame the rules.
No,
If the rules are framed only on the basis of the judgment of this court.
No, the query fell from your lordships with regard to whether, how can a quota be framed if it's not prescribed in 233? I'm submitting that the quota does not emanate from 233. 233 lays down two sources. Now, if I can just show your lordship para 16 of this judgment, it's a little important. Their lordship said, and this is on the same lines as what the Constitution bench had said in Bishan Sarup. Para 16, fixation of quotas or different avenues and ladders for promotion in favor of various categories of posts in the feeder cadres based upon the structure and pattern of the department is a prerogative of the employer, mainly pertaining to the policy-making field. The relevant considerations in fixing a particular quota for a particular post are various, such as the cadre strength in the feeder quota, suitability more or less than the holders in the feeder post, their nature of duties, experience, and the channels of promotion available to the holder.
I think we have not made ourselves clear to you.
I'm sorry, Mr.
We have not made ourselves clear to you. There is no question of quota here. What we are trying to tell you is this. As we have given the example, if 10 posts are there, 7 are earmarked for promotion, there's no way that a lawyer can advocate or a pleader can get into that.
Yes.
That's a separate channel.
Yes.
So where the water will travel, separate water will travel on the travel channel.
Yes.
Which means the remaining 3 is not a quota, it's the only category to be decided on merit. The question is, now can the remaining 3, which you have the 3, forget about the 7, you take this remaining 3.
Yes.
That is the appointment, the appointment you made of the 3. Can in the remaining 3, can you exclude this? There is no question of quota here.
Yes, my answer to your lordship is yes.
7 is.
It can be reserved in its entirety.
One mode of recruitment, you are not eligible. You are obviously not eligible, you go out of it. And in the absence of any eligibility fixed for you to the exclusion of others, you can't stop. That's a very simple question we are putting it to you. Therefore, no question of quota being carved out, this and that. Don't go with the larger issue now.
No, my answer.
You don't bring the promotional post into this.
No, my answer to your lordships is yes. That can be kept only for the.
That's why we say under the Constitution, see, there is no bar. See, that's why we repeatedly were telling you, probably you may have a case, let us say that out of 3, they also apply. In that you give a reason for making adequate analysis after considering the material available. Then you say for A or B reason, we would like to give 2 to the lawyers and leave 1 to the open category. That is something which is different. But yes, the Honorable Chief Justice was saying that is not the way it's been done. It is just on a complete misconception of prima facie, subject to hearing them on Article 233.
May I answer that, Mr.
Yes.
The 75% didn't.
We are clear on this.
Yes.
Yes.
So let me answer it, Mr.
Yes.
The 75% didn't fall from heaven, Mr.
Yes, yes.
The 75% was not like Moses coming down from the mount with a carved in stone. That 75% is to be kept for promotees.
Very well.
The 75% is equally a creation
of the judgment of this court.
No, yes. No. There were Shetty Commission has noted that there were reservations, varying reservations. Some states had them, some states didn't have them. They recommended that there should be uniform, and they said there should be an amendment. Shetty Commission said there should be an amendment to Article 233.
The difficulty we tell you is this.
So I'm.
Yeah, merely because whatever may be the quota, let us say 5%, 10% for the promotee. Unfortunately, the impression is once that the reserve, the promoter, some vacancies are filled up, the remaining should go to the lawyers. We are saying where do you get it in the constitution?
I'm saying, look, I'm answering your lordships. There are, let us say there are 100 posts. 233 says simply that there are two sources of recruitment for those 100 posts. Two sources of recruitment, one is by promotion and one is by direct recruitment. Direct recruitment with the qualification 7 years as a lawyer, as a member of the bar, right? The 233 does not say that 1 or 2 or 10 or 20 or 75 should go to X. That division of 75-25 is in the prerogative of the high courts, as your lordships have said. So I'm answering your lordship.
But 25 will not go to you alone. That's what you're saying. That is meant for open competition.
I'm saying that 25 is a factor of the same division from the two sources. The two sources being direct recruitment from the bar and promotion from the bench, from the subordinate judiciary. And that, whether your lordship say that it should be 10% to the bar or 100% to the bar, I'm saying that is in the prerogative of the state. In this case, the High Court, the governor in consultation with the High Court. That 75% is not carved in stone. 75% was not given to us by some preordained system. That 75 came from the same mechanism. So it either there is nothing, or there is a fixation of. So the basic argument, your lordship may overrule the argument, but let me at least not be misunderstood. The argument is that 233 only lays down the sources, nothing more, nothing less. Now, so far as the mechanism of implementing those sources, the proportionality in what proportion those sources should be exercised, that is the pure prerogative of the high courts in consultation or by rules made with the governor. That's my submission. That's why I'm saying those rules have been framed, and those rules provide for 25% quota. Unless your lordship strike down the rules as being ultra vires 14, 16 or 233 or some other provision of the constitution, those rules hold the field. They are 309 rules. That is the point which I'm making. The point may be your lordship, it may not find favor with the court, but let my
No, we understand.
Now,
we get your point, no problem.
I think that point has been made clear. So the rules, your lordship may just note that say Madhya Pradesh, for instance, the rules your lordship will find in volume 7. Volume 4. Volume 4, there are two, 4A and R. In volume 4A and R, at page 719.
You already taken 10 minutes of Mr. Gupta, so.
Just make a note of the rules.
You will have to curtail his time now.
No, my learned friend Mr. Gupta told me that to complete my point. So
He will have, his time will be cut down from that.
So my lord may just make a note.
Or the other time. Whatever the choice is on that side.
Very well. If I can, I'll put it in a note. But my lord may just make a note. There are several rules, including Madhya Pradesh and Haryana, among others, which specifically provide for the quota. Kerala also provides for the quota. Your lordships are familiar with that. And also Madhya Pradesh, Haryana, among others, provide that if there's any vacancy which is not filled from the quota of the direct recruits from the bar, then, my lords, that will revert back to the promotees, and that will be filled from the promotees will get those leftover vacant seats. Kerala rules categorically provide, lords, for continued membership of the bar. They say there are two separate rules over there which deal with membership of the bar and the qualification of 7 years as an advocate.
Mr. Jaidev Gupta has argued against that.
I'm sorry?
Mr. Jaidev Gupta, appearing for the state of Kerala, has argued
the Kerala High Court in this case and the state lords, for whatever reasons, they may have their reasons, but this is a case, Rajneesh was appointed after this honorable court passed its interim order saying that that all previous appointments we are not interfering with for now because they are already serving. Hereafter, there will be no appointment made of anybody who's from the judicial service. In the teeth of that order, which was brought to their attention, they made the appointment of Rajneesh in the teeth of your lordship's order. So his claiming equities and all is just not available to him.
We are not going into the individual matters now.
I'm sorry. So that is set out in the list of dates is at page 19 of volume 2. So your lordship may just make a note. My submission is that these rules hold the field unless your lordship strike them down. It's not a simple thing of consequentially rules vanishing, because pursuant to your lordship's directions, these rules have been framed under 309 and they are promulgated, they are notified in the gazettes, and they're holding the field. So they get a life of their own, behold the directions of this honorable court. I'm deeply obliged. Because some points may be left out, subsequently your lordship may give some directions allowing us to file.
Already your written submissions are there. We don't want to flood it with again papers.
Submission which are in advance, your lordship know, because so many things fall from due to arguments developed by the other side, or questions fall from the court. We can deal with those.
Well, as I appear in 501.1 for the first respondent, High Court notes.
In 50?
501.1, I appear for the Punjab and Haryana High Court notes. I have given a detailed note of written submissions, Milits, which is in volume 2, page 43 onwards, but your lordship need not bother with it today, Milits. I'll orally make submissions to your lordship today, Milits, and I'll take your lordship to the written submissions tomorrow. Now, Milits, broadly I say this. 233, 1 and 2, both speak of appointment. There's no doubt on that. Both are speaking of appointment. Both use the word, Milits. One uses the word appointment, and the other uses the word appointed. 233.1 also refers to promotion. In what context we will see, but it refers to promotion. It uses the word promotion specifically. 233.2 is clearly referring to direct recruitment because it is talking of Milit's appointment from the bar. It is clearly doesn't use the expression direct recruitment, but it is Milit's clearly speaking about it. 233.1 uses the expression consultation with the High Court. So appointment is common. 1 speaks of promotion. 2 is dealing with direct recruitment. There is no doubt on that. One speaks of consultation. The second speaks of recommended by the High Court. 2 different expressions used, Milits, which have been considered by your lordship.
You consider both in
Yes.
Rameshwar as well as.
So yes. So these 2 expressions. This is what is very clear. It is my submission that 1 is for those who are in service and 2 is for those who are not in service. This is the submission.
According to 233.1
is for those who are in service and 233.2 is for those who are not in service. How do we say that, Milits? Is the question. And the real issue is whether 233.2 is exclusively for those who are not in service. That's the issue, Milits, your lordship is considering. If the interpretation being canvassed by the other side is accepted, then 233.2 is clearly not speaking about those Milits who are in service being permitted. 233.2 is making no reference to allowing those who are in service to be included here, from the words of it. It is an interpretation being given by what is being said is that since it's talking of those who are not in service, but there is no prohibition for those who are in service, therefore they can also participate. That's the Milit's way. But obviously, 233.2 is not directly referring to anybody who is in service. It is not speaking about it. This is very clear. Number 2, what is also equally clear is that while 233.2, which is dealing with direct recruitment, is prescribing the qualification
for those who are advocates. There is no qualification prescribed for those millets who are in service in 233(2). It's an important factor, millets, for the submission I will make. 233(2) is dealing with only direct recruitment. It is providing for a qualification for those who are advocates, that is not in service, but is not prescribing any qualification for those who are in service. So it is not speaking of those who are in service, number one, and number two, it is not prescribing any qualification. Ancillary to that would be the question whether it would be reasonable to say that just the way 233(1) speaking of promotion is not providing a qualification, it can well be that those in service in 2 are also not prescribed a qualification. 233(1) is not prescribing a qualification that is provided by rules. So can it be that 233(2) is also therefore silent? My submission is where direct recruitment is being considered, there, normally there will be qualification for all those who will compete there. It will be incongruous that for one category who's applying for direct recruitment, there is a qualification, but for another category, which is applying for direct recruitment, there is no qualification. It will be incongruous, to put it mildly. Number 2, Article 124 and 217, which I will advert to in detail tomorrow. While they speak of all the jugglery in certain cases, you can add this and that and that and this. You can add your time as a judge in the time as an advocate with certain conditions. Your lordships have in Rameshwar Dayal specifically said that in 233 you can't do that. That Rameshwar Dayal says so very clearly, which means you cannot then say that in 233(2) you have 3 years as a judge and you have 4 years as an advocate, etc. You can't do that here, is my submission. You can't do that. You can't then have the question, which is the fourth question, the second additional issue, whether you can have some years here and some years there. In my most respectful submission, can't be done.
Yeah, I agree with you.
Yeah, that's an important part to answer the fourth issue. That's one important facet. Then,
that was with regard to the number of years of practice in some other high court.
No, I will show that. Rameshwar Dayal has been completely misconstrued in what has been presented to your lordship. In my most respectful submission, and I will make it good from the judgment, Rameshwar Dayal upholds Harbans Singh and Sahni on the premise that they have been advocates for 7 years and they are advocates till their date of appointment as district judges. It says so in so many words. Let's see it straight away. Since it goes to the root of the matter, let us first see Rameshwar Dayal. And let us see, what is the rationale. Certain parts have been shown to your lordship and certain vital parts are yet to be shown. So I will repeat some parts, but please bear with me, It's an important part.
The part that you want to show is at page 112.
No, your lordship may allow me, to place it my way, but I will, show all those parts as well.
That is on the interpretation of the Lahore High Court.
No,
Punjab order.
That also.
For Bar Council Act 1926.
That also, where they conclude that therefore they may not be on the rolls. The requirement is you should be advocates, and they were advocates. That is the rationale, and therefore 233(2). Therefore 233(2). That is what it says. And Chandra Mohan, I will show very clearly says only advocates can come under 233(2). Specifically uses that word, only advocates. And followed later on by another constitution bench, in 2004, is it? 2000, we'll show tomorrow. Now, kindly take Rameshwar Dayal first,
Yes.
Kindly come, the facts are well known, but kindly come to page, 104 in the volume before your lordship. And I have my juniors, yes. Kindly come to the foot of the page, after they reproduce Article 233. Now the argument of learned counsel for the appellant has ranged over a wide field, but the point for decision is a narrow one and depends on whether respondent 2 to 6 fulfilled the requirement of clause 2 of Article 233 of the Constitution when they were appointed as district judges by respondent 1. That clause lays down that a person not already in the service of the union or the state shall only be eligible to be appointed by a district judge if one, he has been for not less than 7 years an advocate or a pleader, and two, is recommended by the High Court for appointment. I pause minutes. Now, minutes, if your lordship sees 233(2), I'll just pause minutes. This is an important line I want to rely upon. 233(2) says, a person not already in service of the union or so-and-so shall only be eligible to be appointed. And here they say, not already in the service shall only be eligible to be appointed district judge. One, if he has been for not less than 7 years an advocate or pleader, and two, is recommended by the High Court. Then, Milits, your lordship may, Milits, on the issue of has been, I'm not coming on that for the moment. Your lordship may skip that and come to the next page at page 106. And please see, Milits, clause 6 for a moment, the middle of the page. My lords have that, Milits? Clause 6 of the order is important and must be quoted in full. 6.1, Milits, is important. The High Court of East Punjab shall have the like powers to approve, admit, enroll, remove, and suspend advocates, vakils, attorneys, and to make rules with respect to advocates, vakils, attorneys, as are under the law in force immediately before the appointed day, exercisable by the High Court of Lahore. Right of audience, etc. Your lordship can skip. The page over, Milits, page 107. Kindly see again the lower half, section 8. Section 8, Milits, and your lordship may come to 8.2. The High Court shall prepare and maintain a roll of advocates of the High Court in which shall be entered the names of A, all persons who were advocates, vakils, pleaders entitled as of right to practice in the High Court. Please mark again, immediately before the date on which the section comes into force in respect thereof. So, Milits, whoever is entitled to practice, etc., immediately before is, Milits, to be mentioned. Then, Milits, your lordship may move down, Milits, 3 pages and come to 110. On a different point of 124 to 117, Milits, I'm reading sequentially, so I'll read it here so I don't have to come back to it. And the middle of the page is the new paragraph. Learned counsel for the appellant has also drawn our attention to explanation 1 to clause 3 of 124. Relating to qualifications for appointment as a judge of the Supreme Court, and to explanation 2 of 217 relating to qualification for appointment as a judge of a High Court, and has submitted that where the constitution makers thought it necessary, they specifically provided for counting the period of a High Court which was formerly in India. Article 124 and 217 are differently worded, refer to additional qualifications of citizenship which is not a requirement of 233, and we do not think that clause 2 of 233 can be interpreted in the light of explanations added to 124-217. 233 is a self-contained provision regarding appointment of district judges as to a person who is already, please mark this, Miller, this is very important. So this is one part, 124-217 you can't read. This is one part which is important. Now the next is also important. As to a person who is already in the service of the union or the state, no special qualifications are laid down under clause 1. The governor can appoint such a person as a district judge in consultation with the relevant High Court. As to a person not already in service, a qualification is laid down in clause 2, and all that is required is that he should be an advocate or pleader of 7 years standing. Now, it may be said, Manoj, I'm arguing against myself, that while it is saying so here, they don't specifically say, no, you can't have other people. But they are not saying here that you can have other people, and I'll refer to other parts to buttress that submission. But here they say very clearly that clause 1 in service, clause 2 not in service. Then let's read further ahead, Manoj. The clause does not, Manoj, then this again is not so important, but kindly come, Manoj, to page 111, just about 10 lines from the bottom. This they are considering, Manoj, the other 3 gentlemen who were, Manoj, advocates at that time. Just the line starting, we consider it unnecessary. Well, it's about 8 lines from the bottom. My lords have that, Milits? We consider it unnecessary to pursue this matter further because the respondents we are now considering continue to be advocates of Punjab Haryana as they were appointed district judges and they had standing of more than 7 years were appointed. They were clearly eligible for appointment under clause 2 of 233. Now, Milits, we now turn to the other 2 respondents, Harbans Singh and Sani, whose names were not factually on the rolls of the advocate at the time they were appointed. What is their position? we consider that they fulfilled the requirement of 233 of the Constitution. Harbans Singh was in service at the time of his appointment. Vishwanath so-and-so, appearing for him, has submitted that clause 2 of 233 did not apply. We consider that even if we proceed on the footprint that both these persons were recruited from the bar and their appointment has to be tested by the requirement of clause 2, we must hold they fulfilled the requirement. They were advocates enrolled in Lahore, that is not disputed. Under clause 6 of the High Court order, they were recognized as advocates entitled to practice in Punjab High Court until the Bar Council Act so-and-so came in force. Under Rule 8.2, which I read to your Lordship, it was the duty of the High Court to prepare and maintain a roll of advocates in which their name should have been entered in the day on which Section 8 came in force. That is so-and-so, September 28, 1948. Proviso to subsection 2 on Section 8 required them to deposit a fee of ₹10 at the Bar Council. Obviously, such payment could hardly be made before the Bar Council was constituted. We do not agree with the learned counsel for the appellant that the interveners, that the proviso had the effect of taking away the rights for these respondents had come to automatically on the roll of advocates under 8.2 of the Act. We consider that the combined effect of clause 6 of the order and 8.2 of the Bar Council Act was this. From August 1547 to September 2848, they were recognized as advocates entitled to practice in the Punjab High Court after September 2848. They automatically came on the rolls of advocate of Punjab Haryana High Court, but had to pay a fee of ₹10 to the Bar Council. They did not cease to be advocates at any time or stage after August 1547. They continued to be advocates of the Punjab High Court till they were appointed as district judges. They also had the necessary standing of 7 years to be eligible under 2 of 233. So, Millets, very clearly, 1 is service, 2 is those not in service. 124.217 can't come here. And here they have been accepted because they are members of the bar as per the rules then. Maybe not under the Bar Council rules today because that's completely different. Suri's judgment sees that. But this is the ratio, Millets, of this judgment. And they say, therefore, the necessary qualification of 7 years is met. That's what they say, Millets, here. This is one part, Millets. I'll continue tomorrow.